Supplementary list, fresh admission, item number 1.
May I pray for 2 weeks time, file a substitution petition, my lord.
No. Tell us what the matter is about.
This is the present applicant already died, my lord.
It's all right. Tell us what the matter is about.
Last occasion, you should be direct to file substitution. Already letter sent to the parties, my lord.
We are not adjourning it, sir. Sorry.
This is the
Despite
present.
adjournment granted on 14 November 2022, steps have not been taken by counsel to the petitioner. The court does not propose to grant any further indulgence. The review petition is dismissed. Yes.
Item number 2.
Madam, can I be excused? I was held up in the lead. There are 2 matters. One, criminal revision. It was listed before Honorable Justice Susikant Mishra. He refused to hear. It was listed before Justice Sangam Swamy yesterday. He also refused to hear.
All right. I'll ask the DR to place it. Not
And one writ petition, my lord. It was specially assigned to Honorable Justice Mahanti, Biswajit Mahanti. Now he has laid demitted office.
all right.
My lord, any available bench suiting the lordship's call.
All right.
I'm grateful.
All right.
Fresh admission, item number 2.
May I please your lordship, item number 2. My lord, the matter is regarding some inflated assessment done by the cell tax authorities and taking into account some forged purchases done on behalf of my farm. I've also appealed before the cell tax authorities and also gone to cell tax tribunal. Cell tax tribunal, they have considered my application and they have directed the taxing authorities to reconsider. And after reconsideration, the point of dispute I was submitting regarding using my forged signature, purchases of 10,70,000 has been made. But that point has not been reconsidered by the tax authorities, and they have simply stick to their earlier decision of 12 lakhs assessment. I have also again filed a second appeal before the cell tax tribunal, which is still pending since 2012. And I am challenging without considering my forged transactions.
What have you challenged here? You have challenged an assessment order?
Yes, of 94-95. They have assessed.
No. Date of, have you got a paper book, sir?
Yes.
Kindly open, look at the prayer clause and tell us which is the order you're challenging.
My prayer is to quash the assessment order.
Where is that, sir?
That is just page 20, my lord.
What is it, page 15? Anyway, this
is their assessment order after my appeal.
So you were challenging, you said an assessment order.
Yes, ma'am.
Where is that order which you are challenging?
That is page 20, my lord. That
20 is the appellate order, sir.
Yes,
If you see first appeal case number, it says, no, page 20.
yes, my lord.
It can't be the assessment order, it's the appellate order. Correct?
Yes, my lord.
Which is the order you're challenging, sir? Let us be clear now. Sir, what are you challenging?
I'm challenging this assessment order.
Which assessment order, sir? Please tell us which is this assessment order.
This is annexure 1, my lord, at page 14.
You have already challenged this in an appeal.
Yes, my lord.
How can you challenge it here?
No, my prayer is if direction can be given for the tribunal to discharge of my.
Where is that prayer? Where is that prayer? There is no such prayer. It appears that the petitioner is challenging an assessment order which he has in any event challenged by way of an appeal before the Orissa Sales Tax Tribunal. permitting the petitioner to approach the tribunal for expeditious hearing and disposal of the said appeal. The court declines to interfere at this stage. The petition is disposed of.
Item number 3.
Published.
My lord, liberty to file an appeal kindly be allowed, my lord.
All right. Counsel, the petitioner seeks leave to withdraw the present petition, liberty to file an appeal as provided in law. Such appeal is filed not later than 1st March, accompanied by an application for condition of delay. Citing the pendency of the present petition as the reason for the delay, it will be considered by the appellate authority in accordance with law.
Original to be returned, my lord.
Yeah, the original will be returned subject to be substituted by attested photocopies.
My lord, a small prayer, my lord. Under the OBIT Act, my lord has extended given time to 3rd of April, my lord. This is under the Anti-Tax Act. I may be obliged, my lord.
All right, till 3rd April. Okay.
Grateful, my lord.
All right.
Item number 4.
May I please, Your Lords? The opposite party number 4 has detained my vehicles on the closure of the year on 31st March 2022, my lord, by making an assessment for the, by imposing tax for the period 19, 20, 2021.
So what you
By
challenged in
invoking
annexure 1 is
section-
simply the summons.
By invoking section 73 subsection 5 of the OGS Act, my lord. While following 73 subsection 5 of the OGS Act, 73(1) and 73(2) has to be followed, but they have not followed it. They have done like by invoking section 16(2)(b) of the OGS Act. So by
They have not
alleging,
passed any order yet. You've simply issued a summons.
my lord,
Have they passed any order yet?
my lord, kindly have a glance to and page 43, annexure 3 series, where they have already closure the proceedings. They have not passed in order to file an appeal. They have said that your availing of the ITC is irregular because you have utilized the non-commercial vehicle while purchasing the materials. That's what they make.
I don't know. I read page 43 very differently. Read page 43.
43, this has reference to show cause notice report above, as you have paid the amount of tax and other dues mentioned in the notice along with applicable interest and penalty in accordance with the relevant provision of the Act. The proceeding initiated by this said notice are hereby concluded.
You're unhappy with this order?
I am unhappy in this.
Why?
Because
What? There's nothing against you in this.
my lord,
There's not a single line against you in this.
my lord,
They are saying you have paid everything. We are closing the proceedings and you're unhappy with it.
my annexure 2 series, my lord, I have already mentioned that the said liability is not acceptable and the submission regarding.
Sir, once they say you have already paid everything, why are you unhappy?
My lord, I am unhappy because for 18, 19, 19, 20, 20, 21, we have already filed a return, pay the tax to the department. Now department says that that period you are utilizing vehicle is irregular. So we pay the
Where
tax.
is the said? You're reading something in page 43 which I am not reading. Show me the word irregular in page 43. Page 43 you just now read, right?
My lord,
Where is the word irregular in that?
they have not mentioned this because they have forcibly collected the tax. So
I don't understand. You're unhappy with page 43. You have to say what is wrong in page 43.
I have unhappy with page 43 because for the period for which they have imposed tax, we have already paid tax for those periods. Why again we pay the tax?
I don't understand. Anyway, it's beyond my understanding, sir.
My lord,
I'm sorry.
for that 3 years,
I don't know. You
we
probably
have
don't
already
understand.
submitted my returns. Can I clarify?
No, let him say, sir. This
My
is
lord,
his petition. He should tell us.
My lord, in
Ah.
annexure 2
In your
series,
returns, these taxes have been shown.
in my return, I have filed to pay the tax because regular filing the return. No.
I don't know. Understand, sir.
My
It is
lord.
honestly, if you say I am aggrieved by page 43, you show this page 43 to anybody in this room, they will wonder what you are aggrieved by.
My lord, page 43 is the closure proceedings. I am challenging annexure 1 series where they have raised a demand in a show cause notice to pay the tax. Why the tax? Because you are wrongly avail ITC
for the period 18, 19, 19, 20.
Sir, this
21.
intimation at page 43, annexure 3 is after that notice. That notice is 19th February. This is
Response to
31st March.
the response to liability intimated under section 73(5) and 74(5). They have already raised a liability under section 73(5)
Anyway.
of the OGS Act as per Annexure 1 series, my lord. So we are against the Annexure 1 series because they have not raised this type of a demand because you have already submitted return to pay the tax. And for the belated period, they have now said that you pay the tax. If you pay the tax, then you have filed an appeal.
Sir,
in
I have to confess my 20 years at the bar, 17 years as a judge. I'm unable to understand your argument.
Sir, my argument is that for the period 18, 19, 19, 20, 20, 21, I have usually filed a return and accepted my tax liability and submitted my return. On 31st March 2022, they have casualed my vehicles on the way and said that there is some irregularities in your business activities and they have imposed tax and they have forcibly collected tax from my cash ledger. That's why there is no way to, there is no alternative remedy to the assessee to approach the authority because there is no appeal provision. So I have before this honorable court because there is no appeal provision. And a similar view has expressed as per the judgment I have already
Mr.
cited.
Patnaik, there is an appeal provision when vehicle is detained.
Under section 07, when it is a closure, there is no appeal. Annexure 3 series, it is their closure, their proceeding closed, portal is not opening. So how can you file appeal? That is whole my problem. If you disagree with the liability what I have been paid, then there is a rule to file an appeal that this is a inbuilt provision to file an appeal. But in the in closure, there is no provision of file appeal. So that's why I have cited the similar situation of the Madras High Court and include that this is a very similar situation. My fact and is same and similar to annexure. To the order I have enclosed before this court. Annexure 4. Similar judgment, similar facts, my lord. There is no appeal provision in the OGST Act. So far as the checkgate matter is concerned, they are forcibly collected tax.
What is your submission?
Your Lordship, everything has been done as per the statute. Your Lordship may kindly turn to
What is the
page 19.
remedy? What is the remedy to him?
No remedy. Your Lordship, he has admitted. Yes. He has admitted and paid the. Your Lordship, just 3 documents. Your Lordship, I may be permitted to show at page 19. DRC 01A, DRC 01A has been issued. Page 20. Your Lordship, may relevant portion.
So he never paid under protest.
No.
Oh,
Your Lordship, I may be permitted to show your Lordship. Annexure 2 series, my lord. Annexure 2 series, it is a protest. Let me, I am showing. Annexure 2 series, page 31. Your Lordship may kindly turn to page 20. Liability is not acceptable.
Sir, when I'm asking you, you did not mention anything. We waited for 10 minutes for you to explain. You could not explain. When I'm asking him, you started arguing.
Sorry. Your Lordship may kindly turn to page 20.
Yes.
The last 3 lines.
Yes.
You are hereby advised to pay the amount of tax as ascertained above along with the amount as applicable interest in full by 7/4/2022, telling which SOCO's notice will be issued under section 73(1). So till this date, SOCO's notice has not been issued. It is prior intimation, only intimation. Now your Lordship may kindly, and in case you wish to file any submission against the above ascertainment, the same may be furnished by 7/4/2022. Now your Lordship may kindly turn to page 32. Annexure 2. He has made the payment, intimation of payment and made voluntarily or made against the SOCO's notice a statement, this payment has been made. Your Lordship on dated 31st March 2022. On the same day, your Lordship at page 43, that has been closed. Now your Lordship may kindly turn to the rule. Rule 142.
Yes.
Rule 42.
142.
142, 1A. The proper officer
Yes.
The proper officer may, before service of notice to the person chargeable to tax interest penalty under subsection 1 of section 73 or subsection 74(1) as the case may be, communicate the detail of any tax interest penalty as ascertained by the said officer in part
1
A
minute,
of-
sir. 1 minute.
Your Lordship.
Because here it reads 142. We have the same thing. Same answer. Yeah. GST.
As the
No,
case- Your
he's using the word may, which is why I'm wondering.
Lordship, may
1A.
Yeah.
Acha.
before service of notice to the person chargeable to tax, interest and penalty under subsection 1 of section 73 or subsection 1 of section 74 as the case may be, communicate the detail of any tax, interest and penalty as ascertained in the said officer in part A of form GST DRC 01A. Your Lordship, this has been issued. Where before service of notice of statement, the person chargeable with tax make payment of the tax interest in accordance with the provision of subsection 5 of section 72, which in this case, or as the case may be, tax interest penalty under section 74(5), or where any person make payment of tax interest penalty or any other in accordance with the provision of the act, where on his own ascertainment or as communicated by the proper officer under sub-rule 1A, he shall inform the proper officer of such form in part GST DRC 03, and that is annexure 2. And the proper officer shall issue an acknowledgement accepting the payment made by the said person in DRC 04. Where the person referred to in Your Lordship 2A, maybe Your Lordship 3. Now Your Lordship 3, where the person chargeable to tax make payment of tax interest under subsection 8 of section 73 as the case may be. Tax interest penalty so and so 30 days of service of notice under sub, where the person concerned make payment the amount effective into so conveyance, he shall intimate the proper officer such payment DRC 03 annexure 2. The proper officer shall issue an order in form DRC 05 including the concluding the proceeding in respect of the said notice. Now Your Lordship, this conclusion has been made at annexure 3. So now Your Lordship, there is no order because there is no agreed. Your Lordship, there is no challenge. So far the DRC 01, he has made payment. He has made payment through DRC 03 and pursuant to that payment, DRC 05 has been issued. Your Lordship, there is no question of DRC 07, which is appealable. So only DRC 07, section 107 says that any order, section 107, so far as the appeal provision is concerned, Your Lordship, that says any person by aggrieved by any decision or order passed under this act. So decision, there cannot be any decision DRC 07 because DRC 05, it has been stopped there. So hence there is no question of appeal or there is no question of passing of order because that has been concluded pursuant to the payment. And forcibly, Your Lordship, this payment has been made through cash ledger. So there cannot be any forcible payment. This is payment. So far as it is a voluntary payment in DRC 03.
Yes, sir.
My lord,
Show us your protest letter.
my protest letter, page 31, my lord.
Where do you say that?
Annexure 2 series, page 31. My learned brother only emphasizing page 32, page 31, my lord. The said liability is not acceptable and the submissions regarding remaining liability are attached given below. Because I am not agree with the liability what the department has already.
Then why did you pay? After saying you are saying this on 6 July.
My lord, suppose somebody will pay the tax irregularly.
No, this is not a protest, sir.
Paid.
No,
So,
protest
okay.
is coming 4 months after they have told you the proceedings are closed.
My lord, I do agree, my lord. I only say that whether something has been wrongly made by the
Not
department.
like this.
Where's
the question? You have to say-
Has been taken away.
No. What
They
you
said
say in
that-
your letter is very important, sir. What you say and when you say is very important. When did you make the payment?
31st March 2022, my lord, on the date they have.
31st March, you made the payment.
Clearly.
No, 1 minute, sir. 31st March, when you made payment, you put no protest. There is a form for protest.
My lord, I do agree that they have.
You have not done so many things that you could do.
No, I have only said that when I paid something wrongly.
Who says wrongly? You yourself don't say it's wrongly.
So
why should they presume you paid wrongly?
So how it is not wrong, when that there was.
Even in this letter, have you said I have paid it wrongly? Just see this letter, page 31.
Page 31, the said liability, whatever liability they have ascertained is not acceptable.
No, you have to say I made payment wrongly. This is what you're now telling us. Where have you said that in this letter?
The said liability is not acceptable and the submission regarding remaining liability are attached.
That you have said after 4 months of deposit.
That I am agree because I have already paid on.
Where did you say in this letter?
Detained.
Where have you said in this letter?
At all not to pay.
Where have you said in this letter you paid wrongly?
They have forcibly collected. I have already mentioned in my read petition, my lord. And a similar situation, my lord, when there is no appeal provision, my lord.
This has come out as final.
The challenge of the present petition is to a notice dated 19th February 2022. Issued by the Deputy Commissioner of CT and GST to the petitioner, requiring him to produce documents related to stock retention and vehicles used in generation of e-way bills for inward and outward supplies. As well as to the intimation dated 31st March 2022 of the tax ascertained as payable under section 73(5) of the Orissa Goods and Service Tax Act, (OGST Act), for the period including liability under the CGST, Central Goods and Service Tax Act, for the period October 2018 to March 2019.
3 periods,
Full stop.
18, 19, 19, 20, 20, 21. 3 periods.
The next period is at page 23, April 19 to February.
Right, comma, April 19 to February 20.
Another is Your Lordship,
And
that
April
is
20 to March 20.
March 20.
All right. Paragraph. The further prayer is that the respondents should be asked to refund the tax and allow the petitioner to prefer an appeal in the portal against the orders at Single Courts Annexure 1 series, unquote, full stop. The background facts are there. The petitioner is a registered dealer and is a distributor of Single Courts Grasim Cement, unquote, for Korapur district. Full stop. It is stated that 4 vehicles loaded with Single Courts Grasim Cement were detained by the authorities asking for production of documents. Stop. It appears that although the petitioner states in para 6 that payment of the demanded tax was made, Single Courts on protest in order to release the detained vehicles, unquote, comma, the fact remains that no such letter recording any single quotes protest, unquote, has been produced before this court. It certainly was not made at the time of payment. Full stop. What has been shown to the court is a letter written by the petitioner to the department on 6 July 2022, disowning the payment of tax and interest. Full stop. The exact wording of the said letter reads, open quotation, take page 31, that subject matter and up to reply. In other words, even the above letter does not state that the payment made earlier was made under protest. Full stop. Paragraph. At this juncture, it is necessary to note that under 142 capital A, capital 1A, yeah, of the OGST rules, 1A bracket 2 capital A, it is open to a person against whom a demand is raised to make a single quotes partial payment, unquote, and also to, open quotation, file any submissions against the proposed liability, unquote, in part capital B of form GST DRC-01A. Full stop. The petitioner did not opt for the above procedure. Full stop. Instead, he made the full payment of the demand, tax demanded by the department without any protest. Full stop. It is only 3 months after making such payment that he chose to write a letter disclaiming any liability and neither saying that the earlier payment was made under protest nor demanding refund of the payment so made. Paragraph. On 1st August 2002, the petitioner was communicated the following letter by the department, reproduce a letter. Paragraph. Initially, Mr. Patnaik, learned counsel, the petitioner repeatedly urged that he was agreed by the above letter. Full stop. When it was pointed out to him that there is nothing in the letter about which he can be aggrieved, his contention was that the petitioner actually made payments under protest and was therefore, and was, on account of the above letter, unable to file any appeal against the demands already raised and which had been paid by the petitioner. Paragraph. If the petitioner wanted to contest the demand raised, he ought to have adopted the procedure already outlined under Rule 142 bracket 1 capital A bracket of the OGST rules. Full stop. For some reason best known to him, he did not opt for that procedure. Full stop. Also, till date, he has actually not registered any protest with the department, which ought to have been made contemporaneous with the making of the payment. Full stop. 3 months after making such payment, he has sent a vague letter containing that the liability is, open quotation, not acceptable, unquote, which is neither here nor there since the petitioner has already made the full payment of the tax demanded. Paragraph. The petitioner has, by his own conduct, disabled himself from availing the remedy available to him in law, if indeed the payment was made under protest. Full stop. Since there is absolutely no material to support the contention of the petitioner that he made the payment of the demanded tax under protest, the court is not persuaded to accept such submission at this stage. Paragraph. None of the reliefs prayed for can be granted. The petition is dismissed.
Item number 5.
May it please your lordships. The issues in this writ petition have been answered by this honorable court 4 times. I am giving the compilations. 4 times I am giving the copy. Lordship will kindly see. First one is WPC 29279, where my lord said that it is obvious, para 5, the impugned assessment order was passed without communicating to the petitioner any draft order of assessment. No draft of order of assessment was given. Para 3.21, I have taken at page 10. I requested that kindly give me an opportunity of hearing, virtual in video conferencing, that also Annexer 11, that the documents is voluminous, kindly give me. Nothing. And second so-called notice. And my lord, the third thing is 1 day time. Lordship will kindly see. Annexer 13 is my adjournment application, and Annexer 14 at page 79. You submit it by 27, giving me only 1 day. And 24th, 25th of December were holidays. I said that it will take some time. Kindly allow me 3 days time. That was also rejected. And on 28th, as if it was ready for the assessment, order was ready. And they passed the order. And clause 7 of 144B says that if any order is violation of the faceless scheme, it is non-est in law. It is totally non-est in law. What I pray, my lords,
No, this is the second round, is it?
no.
Yes. Second round, right?
No, not the second.
My lord, lordship kindly see page 18. Page 18, that is the last opportunity was given. My lord, prior to that.
Why not pass the draft assessment order? Given me the draft assessment order, I have clearly mentioned para 3.21. I have clearly
1 minute, sir,
mentioned.
1 minute, sir, let him.
Sir, yes.
There was my lord so cause notice. Lordship kindly see page 18. There was much earlier to the order of assessment is passed. He had submitted the reply. He was given the opportunity of video conferencing. My lord, he didn't attend. Or the last opportunity that is there.
When did you communicate? Video conferencing?
On 9th December, he was given the opportunity of video conferencing through his mail as it appears, my lord, from page 18.
Oh.
And thereafter, my lord, prior to the decision is taken, order is passed, my lord, there was several communications and he had submitted his reply, and last so-called was notice was given, giving 1 day notice, do I admit, my lord. Thereafter,
That is one part. Where is the draft assessment order?
Yes.
that I have to take instruction on this, my lord. That is not there.
The grievance of the petitioner is that prior to passing of the impugned assessment order dated 28 December 2022 under section 148 of the Income Tax Act 1961 bracket Act, the mandatory requirement of issuing a draft order in terms of section 144 capital B of the Act was not followed. If you come to page 17,
Sir,
the order passed under section, it says 143.3 read with 144B.
144B, that the scheme. 144B. Yes.
No,
144.
so are they saying this is the draft assessment order?
No draft order. Draft assessment order has to be served along with the so-called notice, my lords. And that's what your lordship have held in that Shivascha swine. And same thing has
Although the order is indicated to be under section 143 bracket 3 of the Act, read with section 144 capital B of the Act, a perusal of the assessment order reveals that it indicates the total income determined and issues also issues a computation of income and demand notice under section 156 of the Act, with a further direction to issue penalty notice under section 270 capital A of the Act. Paragraph. Siddharth Rai, the senior counsel appearing for the petitioner, relies on several judgments of this court, including the order dated 27th April 2022 in writ petition civil 10213 of 2022, bracket Sasmita Panda versus ITO, National Faceless Assessment Center, Delhi, bracket, to urge that the violation of the above mandatory requirement vitiates the impugned assessment order and consequential demand. Paragraph. Apart from the above, it is sought to be contended that just 1 day's time was given to the petitioner to submit the documents in response to the show cause notice. And on 28th December 2022, that is 1 day after the deadline of 27th December 2022, fixed by a notice dated
that is annexer, sorry, annexer 14.
by a letter dated 25th December 2022, the impugned assessment order was passed. So in other words, insufficient time was given to the petitioner to even respond to the notice and produce documents. Paragraph. Notice, Mr. Mahapatra accepts notice and states that he will have to seek instructions. Reply within 8 weeks, rejoinder for the next date. Till next date, no coercive steps will be taken against the petitioner pursuant to the impugned order, assessment order, and demand notice, bracket annexures 1 and 2.
Obliged.
23rd August.
Item number 6.
Lord, these impugned orders are appealable, my lord.
All right.
Take
Counsel
liberty to
petitioner
prefer
seeks leave to withdraw the present petitions, liberty to file an appeal in accordance with law against the impugned demand notice before the commissioner.
collector Gajapati, my lord.
No, this is against the
Demand notice is of district excise office, I think.
No, by the superintendent of.
The superintendent is collector, that commissioner is.
to the collector. So if such appeal is filed not later than 3rd April, accompanied by an application for condemnation of delay, explaining the delay on account of the pendency of the present petition, we consider in accordance with law by the appellate authority. The court clarifies that it is not expressed in the matter. If the appeal is filed within the time stipulated, it shall be endeavored to be disposed of within a period of 4 months thereafter, after hearing the parties. And till such time, no coercive steps shall be taken against the petition. The petition is disposed of. All the connected matters.
Item number 7.
Sir, permitted to withdraw.
Dismisses
Your
withdrawal.
Lordship, the name of Mr. S.B. Jaina for OP number 4 may be recorded.
All right.
My lord, my name may be reflected for the ESI corporation. my lord.
All right.
Open number 1.
Item number 8.
May I please, your lordship, item number 8, 9 and 52 may be adjourned to some other date. My lord, Mr. Mahapatra is not well. He's suffering from viral fever.
Regularized services. You've been given a chance to file a fresh representation. And still you're aggrieved. It's a bit strange. No? You've been given a chance to make a fresh representation and still you're aggrieved.
Lordship, Some other day it may be posted, Lordship.
Counsel of the appellant state to be unwell. Next on. Fifth April.
8, 9.
And 52.
Item number 10.
Oblige, your Lordship.
Item 10.
The matter is that the department charged VAT on freight in spite of separate bills for transportation of service of boulders from stone stockyard to port construction site were made by the petitioner. It is a covered case. In the judgment of Odisha High Court, in case of Utkal Molders versus State of Odisha in the year 2010, dated 30 March 2021, it is already submitted in December. And another case of this Honorable Odisha High Court, in case of S. Chandra versus State of Odisha, case number 74 of 2006, dated 17th November 2021. Now, today I am submitting that case.
What's the question sought to be urged?
My Lord, First Appellate Authority did not accept such addition of transportation charges with the sale price, setting aside the order of the assessing officer and granted relief to the petitioner.
Where is he? Where is the question? Yes, it's covered against. Admit the following question is framed for consideration. That take questions at page 11 bottom. In view of the judgment of this court in 17 November, dated 17 November 2021, in STREV 74 of 2006, bracket Messrs. S. Chandra, State of Orissa. The above questions are answered.
Earlier order also, your Lordship may mention that Utkal Molders. Your Lordship has passed the order on dated 30th March 2021.
Many cases have been disposed of in this. Many cases have been disposed of.
Your Lordship.
DK construction is also one of
Your Lordship.
And the order dated 30th March 2021. In SCRB 29 of 2010, bracket Messrs. Utkal Molders versus State of Orissa. 1 and 2 were answered in favor of the SSC and against the department. The issued order of the tribunal and the corresponding orders of the first appellate authority and assessing authority. So the revision petition is disposed.
Item number 11. Item 11.
None is dismissed.
Item number 12.
I am appealing for the respondents, and the issue is squarely covered.
Let me, my opinion.
No, you.
Please wait. Why so hurry, sir? Please wait.
I'm waiting.
Yes.
Because I like you very much. So therefore,
Let's say what I is appearing today.
you are a formidable counsel. Therefore, I have got liking.
Let's say I request let's say 1 week time because I'm not coming with the judgment because the report says nobody is appearing in this case and tracking report is not placed. So I'm not coming with judgments.
I have
So
already
your
received.
name is shown, sir.
No, not.
Opponent is not.
No, no.
Para 15 of the tribunal order.
Come with judgment. Not next to you, Lordship. I'll say next to you. Not come with 60th addition. 3 judgments, Supreme Court judgment. I have no referment. I am not coming with that judgment. I'll just place the judgment. Lordship will decide this issue.
Many water has flown through the Ganges.
Maybe. But I may be.
Only
Para-
you will come with the judgments. I will not cite any judgment. I will just cite only one paragraph of the tribunal. Para 15 at page 32. Lordship may kindly see. Para 15. Coming to the facts of the case under appeal, it is observed that all the assessees had duly disclosed the receipt of advance which is under appeal in their regular books of account, full stop. The assessees claim to have sold shares against their advances in the immediately succeeding assessment year, that is 9-10, and have also paid capital gain tax on the gains derived on sale of such shares. It is not in dispute that related long-term capital gains have also accepted as genuine by the department in the assessment for the year assessment in 9-10. Learned DR could not point out any material which was unearthed. This is also very important. Nothing was unearthed. No incrementing material. Your Lordship, my lords have delivered the judgment in Jami Nirmala, in Smuti Sudha Naik, starting from Kabul Chawla. And nothing has been unearthed during the course of the. Now, what has been unearthed? The long-term capital gain. And I am reading, because of this act, which shows that the advances in question were not genuine, in respect of which additions was made by the assessing officer and confirmed by the CIT appeal. Thus, it is observed that the additions in questions were not based on any such material. Respectively, following the above cited decisions, the learned Income Tax Appellate Tribunal has also followed my lords Kabul Chawla and Mita Gutgutia. The lordship will see at the page 32. First one is a judgment of my lord, that is Principal CIT versus Mita Gutgutia. 395 ITR, and also Kabul Chawla case has also been followed, my lords, where lordship categorically held, if we want to invoke 153A, then 153A is like an reassessment. You have to get some material which has been unearthed.
One day, Lord. I'm not, Lord, whatever says, Lord, I'll just reply one judgment, I'll reply, Lord, because 2-time return, it was not service. Therefore, Lord, I'm not ready. That is why I'm requesting the first.
You are always ready. You are ever ready.
No, 3 adjournments have already been granted.
Yes.
Not only next week, Lord. I have one judgment. I may not be misunderstood. Why? Only one, Lord. I'm just, Lord, 1 week time. Next week, Lord, see any time, Lord, I'll reply, Lord.
No, for which judgment is this?
You have referred, I think, in the
Lord, I'm not reading, Lord.
No, which judgment is this? All this point is crashed,
squarely covered.
threadbare, sir. Nothing new in this point.
Lord,
yes.
Only, Lord, I request for one, but I never asked time, Lord.
No, what is there? There must be some purpose.
You have asked Nidan case 5 times.
Who Nidan case 5 times?
In Nidan, you have asked.
Nidan. Good time,
IDC case. He has mentioned some judgments, 2007, then 1963.
Two more, Lordship, I request 2 more at least.
No, which judgment? Tell us. We'll get it immediately.
I'm not reading, Lord. But I'm not prepared.
Then Kanun Kuti, Uniri Kuti.
I'm not ready. That's why I'm difficult.
I'm not
able to answer, Lordship, a single word, Lord. I'm sorry for that, Lord. I'm not.
No, I'm saying these are all already thrashed, threadbare. There's nothing in this.
Lord, 2 more at least. Not. I said 2 more at least.
All right. List tomorrow.
At
the request of Mr. Satpathy, list. All right.
Much obliged.
Item 13.
The question of law, page 9, my lord. The substantial question of law. Whether in the fashion and structure of the case, the Learned Tribunal was legally justified to dismiss the appeal filed by ITA number 420 CTK 2018 on the ground of a limitation, my lord, without considering the petition of condonation for delay being supported with the affidavit, my lord. There, actually, the 263 order, original order was not served on the assessee. However, getting the order from the London AO, the certified copy, subsequently it was filed and there was a delay 255 days. But without considering
What is there? Oh, you should tell us convincingly what was the reason for the delay. 255 is not ordinary delay, sir.
My lord, sir. My condonation petition, my lord. That's page 23, my lord. It was that due to misunderstanding between the petitioner and his counsel, my lord, the delay was committed. That
No. These are not reasons, sir. The tribunal has, by the impugned order dated 24th February 2020, dismissed the appeal filed by the SSC on the ground of delay. Paragraph. Admittedly, the delay was to the extent of 255 days. Full stop. The ITAT has found the reasons afforded by the appellant to be inadequate and unconvincing, and has accordingly declined to condone the delay. Paragraph. Learned counsel, the appellant drew attention of the court to the application filed by the appellant in the ITAT, seeking to explain the delay. So a perusal of the said application shows that the reasons for the delay are neither convincing nor satisfactory. We'll stop. The mere fact that the appellant came to know of the impugned order of the CITA only at the time of appeal effect being given thereto by the assessing officer and not earlier is not at all convincing. We'll stop. The appellant was expected to follow up with his lawyer on the outcome of the appeal before the CIT bracket A. Paragraph. Consequently, the court is unable to find any reason to interfere with the impugned order of the tribunal. No substantial question of law arises. The appeal is dismissed.
Correction, the CIT, it is 263 order of CIT.
CIT, all right. Order of CIT. All right.
Item number 14.
I am appearing for the department.
Madam Lord, I must apologize for requesting your lordship to reconstitute my brief, my lord. I got the brief, my lord, for removal of defects.
All right.
Some time, lords, to reconstitute.
All right. List on.
I am appearing.
List on 14 February, defects be cured in the meantime.
Copy the So I'll borrow a copy from my learned friend. I'm sorry. I'm sorry.
I have already received the copy.
All right.
Item 15.
Your lordship kept in.
14th February.
Much obliged.
Item number 15.
May I please not? Here, my lord, the respondent, lord, is in the lord from the days mercantile system accounting, lord, is maintaining his books of account, lord, and the provision of provision has been allowed, and your lordship see running page 17 of the tribunal's order. Ground number 1.
Page
17. Internal sales 4 of the tribunal's order. In this regard, Learned Dear replied on the order of the AO submitted the assessee follow mercantile system of accounting as per which liability for expense can be recognized and claimed only when the liability is less not. There is no scope to allow the provision of any expense if the liability for the same has not been displaced or has not become ascertainable by the end of relevant assessment year. This is not one fact. It has not been provision, but not actually not utilized. And second, Lord, the most interesting point of law is Rule 46A. He has produced a document before the first appellate authority that has no opportunity given to the AO to reply the same, my lord. Basing on that government order, the provision has been allowed in favor of the assessment.
Yes. They're all factual, sir. The revenue has filed its appeal against an order dated 25th February 2020 passed by the ITAT Cuttack Bench Cuttack in ITA number 115. Your appeal.
My lord, both the appeal, my lord.
115 as well as 122 oblique CTK oblique 2014.
56.
One appeal being by the revenue bracket ITA 115, the other being by the SSC bracket ITA 122, sorry. Paragraph. The question sought to be urged for consideration by the court in the present appeal. Question sought to be urged. Whether the ITAT was right in holding that, with the SSC having followed the mercantile system of accounting, the provision for liability under the head single quotes dam maintenance unquote is admissible. Is an admissible expenditure unquote. In arriving at the above conclusion in favor of the SSC, the tribunal took note of a
Tribunal only accepted view of
where's the circular? It's a circular, right?
Yes, the first tablet only accepted the tribunal accepted the view of the first tablet authority, my lord.
That's
He
right.
has not concluded.
Relying on some circular.
Yes. The circular of the government, my lord.
That's what. Where is that?
That is, my lord, first tablet authority order.
Oh, it's in the first tablet.
Yes. He has filed before the first tablet, not before the assessing authority.
No, that's all right. Where is that circular referred to?
My lord,
No, it's only on consistency, sir. The earlier years also they've allowed. In doing so, a reference was made to the correspondence, no, to the similar, an earlier order of the ITAT itself on the same issue. In the case of OMC Limited, bracket ITA number 177 oblique CTK oblique 2013, order dated 20th September 2017. Full stop. A reference was also made to the correspondence with the government. It showed that demands were being made in respect of dam maintenance charges. As civil court's early payment, unquote. Paragraph. Adopting the rule of consistency, the ITAT, the CIT-A, and both the CIT bracket A in its order dated 1st January 2014 and the ITAT in the impugned order have held in favor of the SSC and against the revenue. Paragraph. In that view of the matter, the court is not inclined to frame the questions as urged by the revenue in the present case. The appeal is accordingly dismissed.
Item number 16.
Milord 16. Milord, here, Milord, the tribunal is one part, Milord, deleted, accepted the view of the 260 the order. In second part, Milord, he said the AOS, your Lordship, CD start from running page 27, Milord. Internal page 15, Milord, of the tribunal order.
Yes.
As per your considered opinion, as well as the provision of section 263(1) of the Act, as reproduced above, the order of respect of unsecured loan, sundry creditor, liabilities, and sundry debtors accepted by the EU is erroneous and prejudicial to the interest of revenue. We hereby make it clear that the direction of the principal CIT in respect of stock difference found from the record is not required further verification. And in respect of unsecured loan and sundry liability and sundry, the AO has to follow the direction of principal CIT. Your Lordship, it is the petitioner has never produced any books of account before the IO. And the conclusion of the tribunal is not is very cryptic. In the sense, my lord, the stock has not been verified even by the AO. How can the tribunal accepted the view of the petitioner by, the assessee? And one part is delegated, accepted the view of the commissioner, and second part said you cannot verify the same. And let's see the order of the 263, start from page 33.
No, but only partly allowed.
Yes, but if you stock, if one is accepted that the revenue authority has power to delegate for verification.
No, in respect of unsecured loans,
Yes.
sundry creditors and all that, not stock value.
No, he said, may I read again, Lord? He
Yes.
said, in respect of stock difference found from the record, it's not required further verification.
Yes, because that's not the ground on which they're agreeing with the CIT.
But the fact remains, Milord, there is no books of account is produced. It is no books of account produced, Milord. And how Milord tribunal is verify the factual issues of stock and accepted the submission of the respondent, Milord. And one party accepted. And what is the basis? There is not clarified, Milord. If you Lordship see running page 21. On the other hand, DR relied on the presentation or submitted the justified excess power as per so and so. AO issued notice of production of account books and other document even after receiving show cause notice issued and so that they did not produce any books of account. In audit report, so the auditor certified that the cash book stock ledger was maintained. As per the order sheet of the AO, gave many option to the AO. In spite of that, did not produce the books. And AO completed assessment on the basis of finance statement and copy of ledger account available before him, which cannot be considered properly that complete document were produced completing this scrutiny assessment. And he is not views that as if the assessee has produced the statement before the bank for available loan, therefore it should be accepted. Let's see the running page 22, below the 1, 2, 3, 4, 5, 6, 7, 8. The stock act statement very submitted with Punjab for availing cash credit loan. He should have worked out the stock account amount.
All right. Notice returnable 12 July. All right.
Item 17.
Your Lordship, dispense with
Yeah, that's dispensed.
Item 17.
The transfer, file the transfer from Tushar Sati to me. The question raised at page 15. Whether the learned IT is right in relating the addition of 93 crores 77 lakhs for the assessment made by the assessing officer on account of interest and on two reserve fund which were not offered as income by the respondent in complete violation.
No, but
of-
this is, I think, answered against you.
Yes, my lord. Let
Just now. No, Mr. Ishwar appeared the other day.
Yes, yeah, no.
It's covered by that. It's completely covered by that order.
Yes.
Just show
Second
that
question
order.
also covered. Second question also covered. Let him appear and issue.
Why should, what's the waste? What is complete waste of time? It's covered same SSC for the earlier
Same
years.
SSC, yes.
Why unnecessarily issue notice? Just shows that order. That's enough. The two questions sought to be urged by the revenue in the present appeal against the order dated 8 October 2020 of the ITAT. In ITA numbers 210 and 211 /CTK /2018 for the AYs 2013-14 and 2014-15 already stand answered against the revenue and in favor of the SSC by the judgment dated dash this court.
Item 2023 dated 5th January 23.
Dated 5th January 23 in ITA?
ITA
19.
902017.
902017.
90 of 2017. Okay. 90 of 2017. Consequently, following the said judgment, the present appeal is dismissed. All right.
Item number 18.
Same order.
Item number
Another
19.
question is there that the depreciation that is also covered.
That
is also mentioned.
Item number 20.
No, 19.
Sorry, 19.
19, Your Lordship. Question is frame is running page, internal page 12.
Yes.
The question, Your Lordship, though answer in favor of the assessing lord, but there's slight difference in this present case. Whether the fact and circumstance on traveler justified holding when the complete material were produced and not available the assessment during course of original assessment proceeding, the assessing officer cannot reopen the assessment 147 Act even as the income child tax under the assess and escape assessment. The tribunal relied on the judgment of
Kelvinator.
But
yeah. It's all
here,
covered.
this slightly, the difference is the revenues relied on the judgment of the full bench of Commission Income Tax Ussa International versus Limited IT. You will also I quoted the order. Page 6 of my appeal memo. May I please last whole line of this appeal memo, internal page 6.
Yes.
Commission of Income Tax versus Ussa International ITA number so and so.
That's all earlier, sir.
But it is not after.
Ussa International,
Calvin
was
has been
private
considered in the full bench. Calvin has been considered in the full bench.
Yeah. But
Here,
it's all-
the Honorable Court says the entire gamut of change opinion has been analyzed in the background of Honorable Supreme Court in decision of the Calvinator, India, which does not approve the decision of land travel in present case.
Yes.
And then Ussa International.
Yes.
The major judgment held the change of opinion postulate formation of first instance, then change thereof. As the AO did not admittedly examine the issue during the course of original assessment proceeding, the Honorable Full Bench held that there cannot be a deemed formation of opinion. It may be submitted here that the issue on which the assessment was reopened under 147 of the Act in the present case has not been examined by the during course of original assessment proceeding. Thus, there is no inference on the part of the AO to keeping recourse of section 147 of the
Say, the challenge by the revenue in the present petition, in the present appeal, is to an order dated 28 January 2020, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, in ITA number 272 and 246 /CTK /2017 for the AY 2010-11. Stop. The question sought to be urged by the revenue is whether the ITAT was justified in overturning the reassessment order passed in respect of the respondent SSC for the AY in question, following the judgment of the Supreme Court in CIT versus Kelvinator of India Limited, 320 ITR 561 bracket SC, question bar. Paragraph. Factually, it was determined by the ITAT that the SSC had furnished all relevant documents and details at the time of original assessment, and there was no new tangible material unearthed by the revenue which would justify the reopening of the assessment. So it is further held that merely because the assessing officer may not have applied his mind to the materials produced, would not enable him to reopen the assessment merely on the basis of the same material. Full stop. Paragraph. Having heard learned counsel of the department, the court is not satisfied that any error has been committed by the ITET in following the judgment of the Supreme Court in CIT versus Kelvinator of India Limited, Supra, and rejecting the plea of the revenue. No substantial question of law arises. The petition appeal is dismissed.
Item number 20.
And the question has been framed at page number 10, my lord. That within the facts and circumstances of the case in law, the ITAT is urged in upholding that the decision held by the CIT appeal that the case was barred by limitation and the AO should have passed the assessment order on or before 18/10/2016. And second question is that whether in the facts and circumstances of the case and in law, the ITAT urged in upholding that the assessing officer has not completed assessment within the prescribed time as per section 153B, section 142A6 without considering the exclusion of period commencing from the end of the month in which the reference was made to the valuation officer and ending up with the date on which the such report was received by the AO as and permissible as per explanation 2A letter enumerated to explanation 3 of section 153B. And the last question very important, whether in the fact and circumstances of the case and in law, the ITAT urge is not considering the condition laid in section 142A7 to be followed by the AO for making assessment taking into account the report of the department valuation officer. Mirror the tribunal order as page. It's 4 or 5 grounds are there. At page 81, on pursuit of the above finding of the CIT appeal, we noticed that the payment made to Kamalini Berela was towards settlement of the dispute arising towards purchase of the land, out of which 30 lakhs were paid in the previous financial.
No, what about this limitation? I think one was a limitation, sir, under 153B.
153B, notwithstanding anything contained in section 153, the assessing officer shall make an order of assessment or reassessment. It is a
because it was not decided on merits, it was decided on the issue of limitation.
Yes.
Ah.
Yes, that in respect of each assessment year, failing within 6 assessment year, referred to in clause B of section 1 of section 153A within a period of 21 months from the end of the financial year in which the last of the authorization for search under section 132 or for requisition under section 132A was executed. Second is same 21 months in respect of the assessment year relevant to the previous year in which search is conducted under section 132 or requisition is made under section 132A within a period of 21 months from the end of the financial year in which the last of the authorization for search under section 132 or for requisition under section 132A was executed, provided that in case of other person, not other person.
No, come to para 18, sir, page 46.
18.
Para 18, page 46.
From the above order, it is clear that
The CIT appeal was considered the issue in details as raised by the SSC before the regarding challenging the assessment order passed by the AO that it was the time barred in which has no value. The assessment had been completed under section 153A. We also observed the assessment order is not in accordance with the prescribed time limit as per 153B of the Act, as per the amendment provision brought by the Finance Act 2014. The valuation officer has to submit the report within 6 months from the end of the month in which the reference has been made to him. In this case, the report of the valuation officer has been received on 3rd October 2016 by post. In the improved case, the case was referred to the valuation officer as per section 142A6 of the Act for determining the cost of investment, construction in the property of Siddhivinayak Enclave, Lakshminagar, near Yatrinivas, Cuttack Road, Bhubaneswar. On observation of the variation report at page number 42, para 32 of the paper book submitted by the SSC, that as per the observation, the SSC has duly complied the technical data and date of inspection of property was 13/5/2016. However, the valuer has submitted his report after expiry of the 6 months, 13/5/2006 and 3/10/2016. Whereas the AO specifically mentioned in the letter with the written to him that it is a time barring case and the valuation report is to submitted up to 5th March 2016 as per the amendment provision. If the SSC has not complied the direction of the DVO, he may estimate the value of the assets, property or investment to the best of judgment. As per the finance bill is important. As per the finance bill 2014, the gist of amendments given agenda. Then last, if the SSC does not cooperate or comply with the direction of the valuation officer, he may estimate the value of the assets, property or investment to the best.
So what do you have to say? If it is not time barred?
Yes.
If it's not within 6 months, it's factually, there's no question
After
of law
6 months.
arising. There's no question of law that arises. It's all factual. Whether the valuation
CIT
report was
appeal
submitted within 6 months is a fact. Can't overcome that. It's no fact.
CIT appeal order is important. CIT appeal partly allowed. There are only 2-3 points are there.
No, CIT appeal went against you even on limitation, I think.
Yes.
So concurrent findings are that it is time barred.
The ground number 3 is important. At page 124, that the contest assessing officer has passed the order without approval of the Joint Commission of Income Tax.
That is different, sir. That approval of Joint Commissioner is a different point. We are on limitations. All right. This is the revenues appeal against an order dated 14 December 2020 passed by the ITA Cuttack Bench, Cuttack. In ITA SS numbers 188/CTK/2019 and ITA SS numbers 56-58/CTK/2018 for the assessment years 12-13, 14-15 and 15-16. Paragraph. Sir, how do you file one appeal here against all orders? In other high courts, they don't number it also.
I filed 2 appeal. 20 is also there.
I see. Then you put 99, 20.
It's a 90/2021. Another appeal is.
No, but these are 4 years, sir.
Because two are below monetary limit. 1 crore.
Which years then are you preferring? Because you're putting all numbers.
Yes. 4 numbers are there.
All right. You say for the years. No, you have said 12-13 to 15-16.
No, first line. First 12 for 13-14. This is for 13-14. And last line is for 12-13 to 15-16.
I'm saying you're putting all years together.
No, because 2 years they are below 1 crore, so department has not filed appeal. I filed for 13-14 and.
Anyway.
1314 and 1213.
All right. One of the questions urged for consideration is whether the ITAT erred in upholding the decision of the CITA that the revenues case was barred by limitation, since the assessing officer bracket AO did not pass the assessment order on or before 18th October 2016 in terms of section 153 capital B, read with section 142 capital A bracket 6 of the Income Tax Act 1961. Paragraph. Relevant to the above question, the brief facts are that a search and seizure operation under section 132 of the Act was conducted in the business premises of the respondent SSC, business and residential premises of the respondent SSC. Respondent SSC's promoters or directors on 24th October 2013. Paragraph. Notice thereafter was issued under section 153 capital A of the Act on 9th March 2015. The SSC filed returns of income on 5th January 2016, showing a total income of nil. Full stop. The AO then made a reference to the valuation cell for determining the cost of investment of the construction in the property at Bhubaneswar. The valuation report was asked to be submitted on or before 5th March 2016, since the case was going to be barred by limitation on 31st March 2016. Paragraph. Admittedly, the AO received the valuation report only on 3rd October 2016 by post and by email on 27th September 2016. Full stop. Thereafter, he issued the statutory notices and completed the assessment for the aforementioned years by the assessment order dated 25th November 2016. Paragraph. Both the CIT capital bracket A and the ITAT have found that by virtue of the amendment to section 153 capital B of the Act, the assessment had to be completed within 24 months from the end of the year in which the search was made. Paragraph. With the search having been conducted on 24th October 2013, the assessment had to be completed by 31st March 2016. Full stop. 21 months. From 21 months. The contention of the revenue is that if the AO chose to make a reference to the valuation officer and under section 142 capital A of the Act, valuation officer had 6 months time to submit a report, then that period could not be counted for computing the period of 21 months from 15th January 2016. Paragraph. There is nothing in section 153 capital B that envisages the exclusion of any period during which a reference is made to the valuation officer. Full stop. Taking section 153 capital B of the Act as it presently reads, it is plain that the assessment has to be completed within 21 months from the end of the period
24 months.
when the search is completed. But it's time barred even if you say 24 months, sir. Because the assessment is completed on 25th November.
No, 24 months. Well, page 6 of the petition, the time limit to complete the assessment 153 is IT Act is 150 is 24 months from the end of the year in which the search was made.
No,
In
but
this case,
the amendment says 21 months.
Your lordship, it already order has been, it has been amended. If a search is conducted prior to 1/6/2016, it will be 24 months.
But either way, sir, even 24 months,
Correct, sir.
if you take it, then it has to be completed by 31st March 2016.
I have to make the calculation.
From the end of the year in which the search was made. Search is made in 2013.
That page 6, my lord, only just. That
Sir,
in this case,
end of the
search
year
was-
in which search is made, the end of the year is 31st March 2014. So search is made on 24/10/2013, right?
Yes, yes,
End of the year is 31st March 2014.
yes.
2 years from that,
31st March
2016.
Yes.
Assessment is completed on November.
November.
Either way, even if it's 21 months or 24, you put 24 itself. You see, it is plain that the assessment in the present case was not completed within 24 months of the end of the year in which the search was conducted. That is on or before 1st April 2016. The assessment was completed only on 25th November 2016. Paragraph. Consequently, neither the CIT-A nor the IT-AT was an error in holding in favor of the assessee and against the revenue on the above aspect. Paragraph. No substantial question of law arises. The appeal is dismissed.
Item number 21.
21. Substantial consider page 9. On the fact and circumstance of the case.
Again, no incriminating material found, sir. Same thing. Again, 153A, same thing, sir. It's all covered by our own judgments here in this court. The revenue appeal is directed against an order dated 14th December 2020 passed by the Income Tax Appellate Tribunal in ITA number, ITA SSA number 69-75/CTK/2019 for the AYs 2009-10, 2015-16. Full stop. Among the questions sought to be urged before this court by the revenue is whether the IT-AT was justified in deleting the additions made during the assessment under section 153 capital A of the Act on the ground that no incriminating material is found during the search to justify the additions. Question mark. Paragraph. The above question already stands answered against the revenue and in favor of the SSC by a series of judgments of this court, including, give me one judgment of this court, sir. Several judgments have been issued on 153A. Consequently, the court is not inclined to frame the question as urged. The appeal is dismissed.
Item number 22.
Lordship, here the question is not the section 40AI of the income tax is a declarative and curative as to retrospective or prospective not. That is the issue involved here. Because the Finance Act, not Act 2012, Finance 2012, so the financial year not.
No, unless it actually says it's retrospective, it can't be, sir.
But the fact remains not, Lordship judgment is not thereafter, 2029/7/2022, Sri Chaudhary Transport Company in 40A, but earlier amendment, the Supreme Court says the date of insertion of the amendment, it will be operative. In
Will
your
be?
date of inclusion of the amendment, date on which it was included, not prospective from the date.
Not retrospective.
Yes.
So it's against you then. You want it to be retrospective, so it is not retrospective.
My lord,
No, but that's not agreed to. Yeah.
your my lord,
Yeah.
your lordship
No,
felt that
certainly
it is be retrospectively, it will be
It won't serve. In fact, in tax law clearly it says WREF, where they intend to make it retrospective.
financial year, my lord. Yes, this is the my lord financial 12 and 14. And the amendment took place, my lord, in 2012.
No, this is assessment year 12-13.
Assessment year 12-13, not
correct.
And the amendment taking place, my lord, 2012. 40 AI, my lord, 2 times it was amended. 48 2 times it is not amended. And my lord, this Sri Chaudhary transport, my lord, in 29/7/2022, my lord.
That actually.
Anshul Lord, the
where does the tribunal deal with it, sir? Let's read
that
that.
is page 33. Paragraph number 22, start from paragraph 22. In this case, assessor has furnished certificate from chartered accountant, annexure 1, form 26A, in respect of interest payment to NBFC, and the AO was not raised an objection or doubt regarding certificate furnished from the chartered accountant regarding interest payment during the financial year 11-12, but only basis of denying the benefit second proviso of 40A IE of the Act. Delhi High Court in case of Ansal Landmark Township Private Limited Supra held that the second AIA of the Act declared curative and has a retrospective effect from 1st April 2005. Being the date from which clause AI and 40A was inserted in financial year 2004. Respectively following say, we hold that the benefit such provides are available to the assessment and transaction payment made during the financial 11-12 and 12-1-4-11 to 13-12.
That's the answer. What have you done in Ansal Landmark? Was that challenged?
Not check. I have not.
Then can simply keep multiplying, sir.
I have not checked. Not. And here, Milord, the judgment Sri Chaudhary Transport Supreme Court says, Milord, the date of in 40 AI 2005 says, Milord, the required to from the date of insertion of the said provision.
So 1/4/13 has come. So 13-14 financial
Yes,
year.
it is prior to that.
This
Prior to that.
Insertion is 1/4/2013.
2000, yes, 2000.
So that is 13-14 financial year.
It is financial 2012. It is assessment of 12-13 means 11-12. Financial year 11-12, assessment year is not 12-13.
In a question of law,
yes,
page 17.
Was inserted Finance Act 2012. Assessment year is 12-13, financial year is 11-12.
You see, Finance Act 2012 and came into force with effect from 1/4/13.
Correct.
That means 13-14 financial year.
Yes.
It came into force with effect from financial, it affects the financial year 13-14. So your financial year is
11-12.
11-12. So you seek it to be applied retrospectively.
No, SSC sought it.
Assess
It wants it to be
it is a declarative and curative, therefore it is be retrospective. I said it is date of insertion of the
No, but,
amendment.
it's been held against the revenue by Delhi High Court. Just come to
Yes, Lord, I have.
page 29. They followed only Delhi High Court.
That is the order, not the Delhi High Court judgment. Lord.
Yeah.
That is clear, says.
Correct. Unless the appeal against Delhi High Court, but it's beneficial to the assessor.
Only Lord, the Supreme Court, I have checked in Supreme Court the date of, if it is helpful to the revenue, Lord, I don't know, Lord, exactly. But you will also see the judgment, Lord, may help somehow.
The revenues appeal is directed against a judgment dated 22nd January 2021 of the IT-80 in ITA number 109/CTK/2020 for the assessment year 2012-13. Paragraph. Among the grounds urged by the revenue before this court is whether the IT-80 was justified in deleting the addition made by the assessing officer to the taxable income of the SSC by treating the second proviso to section 40 bracket small a bracket small ia bracket of the Income Tax Act 1961 as having retrospective effect from 1st April 2005, the date on which subclause bracket 1 small a of section 40 bracket a of the Act was inserted. Question mark. Paragraph. In answering the above question in favor of the SSC, the IT-80 has in the instant case relied on the judgment of the Delhi High Court in Ansel Landmark Township Private Limited versus
CIT versus
CIT versus Ansel Landmark
Township
Limited. 1 minute. 279 CTR 384 bracket Delhi. Paragraph. Counsel for the department is unable to inform the court of any appeal having been filed by the revenue against the said decision of the Delhi High Court, which has resulted in the reversal of the said judgment. Paragraph. Having heard learned counsel for the department, the court is not persuaded that the IT-80 has erred in its conclusion following the judgment of the Delhi High Court, which appears to have been accepted by the revenue. Full stop. Consequently, the court is not inclined to frame the question as urged. The appeal is dismissed.
Item number 23.
There's some corrections to be made in the last term. There's some correction to be made in the Lordship's order.
Yes. Just the correction be carried out. All right.
Item 24.
Sorry.
My lord, item number 24 is a PIL matter. Defects regarding non-compliance of Rule 8 of Odisha High Court PIL rules has been pointed out by the SR. My lord, the matter can be disposed of as the representation under Annexure 4, page 27, dated 26 May 2022 is pending before the collector Sundargarh, my lord.
All right. The petitioner's representation dated 26 May 2022 shall be examined by the collector Sundargarh and after notice to the petitioner. And after seeking inputs from the State Environment Impact Assessment Authority. And after giving the hearing to the petitioner, a reasoned order shall be passed not later than 17th April 2023 and be communicated to the petitioner within a week thereafter. The court clarifies it and not expressed anything in the matter. Oh, bless you.
Item 25.
May I please listen. Unless there is a correction which is required.
Yeah. Corrected as pointed out.
Oh, bless you.
Same. Item 26.
Permitted to withdraw, my lord.
Dismissed as withdrawn.
Item number 27.
My lord, I am filing the copy of the order of the Honorable Apex Court. The interim order which was challenged before the Honorable, it is relating to Somali plan. And the Honorable Supreme Court has disposed it off. They have withdrawn the appeal.
Oh, I see. Against this court's order?
Yes.
I see.
And in the interim order, your lordship has decided
Yes, yes.
that
Nothing survives then.
nothing survives.
All right. It is seen that when order dated 5th January 2023, the Supreme Court of India has dismissed SLP Civil Diary number 3734732 of 2022, filed against the order dated
12th July
2022 of the court of this court in writ petition civil 13241 of 2022 as withdrawn.
My lord, that is IA number 8432 arising out of 13. It doesn't. The impugned order before the Honorable Supreme Court was passed in IA number 8432 of 2022 arising out of WPC 13241.
All right. IA number 8432 of 2022 in WP Civil 13241 of 2022. Paragraph. This said interim order answers all the questions raised in the present petitions against the petitioners. Stop. It is nevertheless clarified that it will be open to the petitioners if there is any grievance regarding improper implementation of the R&R policy.
Yes. They can approach the collector.
To approach in the first instance the collector and thereafter seek appropriate remedies in accordance with law. Full stop. The petitions are disposed of.
Your lordships, kindly allow me to argue my case, your lordships. At that time, your lordships, interim order, by the time when the interim order was passed, your lordships, the rejoinder was not filed, the counter. So your lordships had said that opportunity will be given in the final hearing. So
all right, argue, no problem. Yes, okay. All right. Which is your matter, sir?
He is in the main matter, 1324.
In which matter the interim order has been challenged before the Honorable Supreme Court.
13241.
Lordship.
All right. Argue, sir.
My argument is basically.
Let's go back to the prayer, sir.
I have a humble request, your lordships. Kindly allow me to make my submission. Thereafter, I will be in a position to answer all your queries, your lordships.
All right. Basically, you're saying don't ask me any questions.
I'm not saying that, your lordships.
All right. Because all right. No problem, sir. No
I
problem.
prepared a small.
No problem. No problem. Just argue. Just argue. He'll keep quiet. Argue, sir. Yes.
Basically, your lordships, my argument is of twofold, your lordships.
Yes.
First part is the legality and enforceability of that scheme, and second part is the applicability of the act, your lordships, which your lordships has taken a prima facie view, your lordships. So first, your lordships, in my humble submission, your lordships, by virtue of a scheme, they cannot take away my constitutional rights guaranteed under 300A, your lordship, Article 300A, without resorting to any statutory provisions, your lordship. By virtue of a scheme, they cannot override the statutes provided to acquire the lands, even if the petitioners are residing over the government lands, your lordships. There are so many statutes, and the due process has to be followed by the state to take away the immovable property of the petitioners and to displace the petitioners from their property, your lordships, immovable property. And by virtue of a scheme only, they cannot take away all the statutory rights and constitutional rights guaranteed to the petitioners, your lordships. That is my first submission, your lordships. And in that, your lordships, I would like to quote the Honorable Supreme Court, your lordships. In the case of the Reserve Bank, it's in the second case. That is your lordships, Punaram versus Motiram, civil appeal number 4527 of 2009, your lordships. Here the Honorable Supreme Court has said it could not be.
Sir, are we entitled to, or should we not even ask you to give us copies of the judgment?
Lordships.
Is it okay for us to do that?
No, your Lordships. I
okay.
said.
And what about the other side, sir? Is he entitled to a copy?
I'll provide a copy.
Not entitled. I think we'll give him a copy. Oh, it's okay. Yes, sir.
Here the Honorable Supreme Court has settled that it could not be disputed and is by now well settled that settled positions or effective positions of a person without title and title seem to protect his position as if he were a true owner, your Lordships. So considering this long position of the petitioners, it cannot be said that when the petition...
No. Was the possession in that case on a government land or private land? In the case which you're just citing before us,
Lordships,
the land in question was government land or private land?
A private dispute.
Private, but your Lordships, the issue was, your Lordships, whether when a person is residing there or occupying the lands for a since long, then his possessions each considered.
Will it be the same, sir? I'm actually a bit ignorant of the law, but tell me, if the land is government land, is the law is the same as the land being private land?
Your Lordships, even if it is a government land, that the adverse possessions comes into play when it is, even if it is a government land also, your Lordship. That laws apply to the private land also.
Which law, sir? Show us the law, sir. Please show
the
us.
Limitation Acts, your Lordships.
Show us.
In my rejoinder, I have mentioned that, your Lordships.
Let's see that.
Limitation. Yes. Para 7, your Lordship, page 11.
What have you said there, sir?
Section 27 of the Limitation Acts provide that in case the person has not taken any action for recovery or possession of land during the period of limitation, then his right gets extinguished. Accordingly, even if the petitioner residing over the government recorded as government land and the rights of the government of Odisha has been extinguished by of adverse possession by the petitioner over the said land.
This is just an averment, sir. Where is the legal position? Where is the limitation?
Limitation effective about it. And Article 112 of the Limitation Act, 1963.
Article
112 of the as per Article 112 of the Limitation Act 1963, for the claim of adverse possession against the government property, the period of limitation to run is 30 years.
How do we know who are you? Petition number 1. No. How many petitioners are here? Forty-four,
Lordship.
So what are the facts you have pleaded for each of these 44 to attract this?
Your Lordship, it is clearly visible that from the ROR, your Lordships, they have been occupying the land And it has been mentioned in the last column, Your Lordship, that they have been occupying the lands for more than 30 years, Your Lordships. I have annexed all those RORs in relation to their occupation, Your Lordship. Annexure 2 series, Your Lordships. And that is of the year 1981. That was published in the year
But this
19.
will have to be proved in a suit.
This.
It will have to be proved in a civil suit. But can't be done in a writ petition. You have to prove it in a civil suit. You can still, if you want to institute a civil suit, by all means do that. That may be a better course for you. If this is your point, you file a civil suit and you get your reliefs in the civil suit.
That was my point for the implementation of the scheme, Your Lordships.
No.
So
if you now want to have a declaratory title on the basis of adverse possession, you'll have to go for a civil suit.
But Your Lordship, the problem is that, Your Lordships, till I file a civil suit, all the house will be demolished forcefully.
Civil suit can be filed tomorrow morning. We do not have to teach you how to draft a plaint and all that.
If Your
If
Lordship provide me the protection and
No,
until the
not
filing
necessary. There is a court there. In Sambalpur itself, there's a court which will grant you that protection if you make out a case. We don't have to grant you. You go to the civil court in Sambalpur, you go with a plaint, you go with a suit, you go with an order 39, and they will hear you and pass appropriate orders.
Until I may be
Not
protected
necessary.
because
When that court is there, why should we pass orders?
Because they are forcefully demolishing all those buildings. I have filed.
In fact, we vacated this interim stay long ago.
And in the meantime, they have already demolished so many houses.
See, we are not here. So we are not here to give you free legal advice. All
Lordships.
right. You decide what course you want to adopt. If you want to urge these points, this can be best done in a civil court because somebody will examine each of your cases. The ROR, the Tahsildar will be called, document will be marked, original document will be looked at, registers will be looked at, identity of the persons will be looked at. All right, all that elaborate exercise only a civil court can do.
Lordships, I agree with your Lordships, fully agree with your Lordships. But my problem, the problem of the petitioners are.
That can't be. See, the problem really is this. You have a remedy, you have to seek that remedy.
Lordships.
All right. What relief you'll get if you invoke that remedy, you can't expect it to be given here at this stage.
No.
It will be done by the appropriate court after being satisfied with your case.
Lordships, my humble submission was because of your Lordships, the implicability of that scheme. I point out all those points that how you, by virtue of a scheme, they cannot take away all those rights guaranteed under all those statutes and the articles. So it was one of my submission, your Lordships. May I move to the other submission?
Yes.
That in my humble submission, the first submission was that the scheme is not in accordance with any statutes or articles of the Constitution. The second is, your Lordships, applicability of the Act, your Lordships. Which your Lordships has taken a prima facie view that if the petitioners are residing over the government land, the Act will not be applicable to the petitioners, your Lordships. In that regard, your Lordships, my humble submission is may I quote another judgment of this honorable?
Yes.
Para 37, your Lordships.
Yes.
After 2-3 lines, your Lordships. I am starting from a statute.
Yes.
A statute is best interpreted when you know why it was enacted. With this knowledge, the statute must be read first as a whole and then section by section, clause by clause, phrase by phrase, and word by word. If a statute is looked at in the context of its enactment with the glasses of the statute maker provided by such context, its scheme, the section, clauses, phrases, and words may take color and appear different than what the statute is looked at without the glasses provided by the context. With these glasses, we must look at the act as a whole and discover what each section, each clause, each phrase, and each word is meant and designed to say as to fit into the scheme of the entire act. Next para, your Lordships. No part of a statute and no word of a statute can be constituted in isolation. Statutes have to be constituted so that every word has a place and everything is in its place. It is by looking at the definition as a whole in the setting of entire act and by reference to what preceded the enactment and the reasons for it that the code constitute the expression. So it relates to. But the observation is that, Your Lordship, the statute has to be read as a whole. And the one word cannot be read in isolation, Your Lordship. May I proceed, Lordship?
Yes, please.
Your Lordships had earlier pointed out that Section 2, the applicability of the Act. The provisions of the acts relating to land acquisitions, where these questions are of whether the land acquisition, why the government will acquire its own land. But these acts, under the different interpretations, have covered the government land also. In my humble submission, Your Lordships, there is no specific mentions of government land and private land in the statute. The law is silent over that. But if we go into the other sections of the land, words and phrases of that section, it will be applicable to the petitioners also, Your Lordships, because they are coming on. Kindly have a glance to the definitions.
Sir, is it okay to ask questions or we should not ask any question?
Your Lordship may ask.
Thank you for the permission, sir. So, are you seriously suggesting that under this land acquisition law,
Lordship,
government will acquire its own land?
When the land has been, the petitioners are in occupations of the land since long, and they are coming under this act, under the various.
The petitioners are coming under the act or the lands are coming under the act?
The petitioners are coming under the land act because, Your Lordship, they are holding the land, and here it has been
if
defined.
Somebody occupies government land,
Lordships,
government has to acquire that land.
Government has to acquire the land provided
I see. Any judgment which tells you that all these land acquisition law, this 2013, all meant to apply to government land, that government will acquire its own land, according to you.
When the government has lost, when the petitioners are residing there since long, they have.
So you have any law which says if somebody is residing on government land for long, government has to invoke this act to acquire that land?
The act itself has prescribed, Your Lordship. Kindly have a glance.
No, I'm asking you, is there any judgment for that?
I have not gone through any judgment, but the act itself is explanatory, Your Lordship, because there are so many definitions. What is the owner of the land? What is holding of land? All that has been explained in the definition section, Your Lordship.
Carry on, carry on.
Holding of land. May I read, Your Lordships?
Sir, all permissions granted. You don't have to ask for permission. All permissions. When I ask you a question, I'll ask permission. All right. And you can grant me permission. As far as this side is concerned, all permissions granted. All right. You don't have to ask permission. You just make submissions.
If I have committed any mistake,
I beg apology. It's an education for us. It's an education for us. Yes.
I may have been misconstrued, Your Lordship,
No,
but my intention was not that I had prepared a submissions so that I did not want to break that submission, Your Lordship. That's why I requested this honorable court. Kindly see the definition of the holding of land. Means the total land held by a person as an owner, occupant, or tenant, or otherwise. Even if somebody is a occupant also, he is coming under the land. He is coming under the definition holding of land, Your Lordships. Then it comes land owner, Your Lordships. And I'd like to draw your attention to surplus 3, Your Lordship. A landowner includes any person who is entitled to be granted pata rights on the land under any law of the state, including assigned lands, Your Lordship. So the petitioners are entitled to get the pata rights under Section 8A of the OPL Act, Your Lordship. And the proceeding has to be initiated by the government state. The petitioner cannot proceed under 8A, Your Lordship. So motto. The proceeding has to be initiated by the state. they have to make a encroachment case. Thereafter, if the state finds that the petitioner are residing for more than 30 years, under section 8A of the OPLE Act, the state has to provide quota to the petitioners, persons or occupier, those who are residing there over 30 years, your lordships. So under section land honor, your lordships, the petitioners are entitled to get the patta rights, your lordship. In my humble submission, your lordships. Land, may I go to the definition of land, yours? Includes benefit to arise out of land and things attached to the earth permanently fastened to anything. And third is, and the last one is affected families. A family whose land or other immovable property has been acquired, land or other immovable property, even if the land is recorded as the government land and that has they have not challenged the ROR, your lordships, then the act says that a family whose land or other immovable property has been acquired. So even if they are residing over the government property, your lordship, and have constructed their Paka buildings, which is their immovable property, if the government will acquire those immovable property, this act will come into play, your lordship. These are my humble submission, your lordship.
Yes. You're done?
Lordship.
Yes, sir.
Yes, my lord. So far as the plea of adverse possession which my learned friend is advancing, if your lordship will see the entire pleading, there is no such claim at all. And more so in a writ petition, such a plea is inadmissible and misconceived. Only thing he is praying that the scheme which we have formulated, according to him, it is not in consonance with the 2013 Act, so it should be quashed. So far as this scheme is concerned, we have filed counter affidavit showing that this is a scheme which is in terms of the 2013 Act. Rather, we have given better facilities to some of the encroachers having, and we are giving alternative land to them. So the focus is on the scheme. As per the writ petition, the focus is on this. They never claim that we are the rightful owner, we are the title holder, the land should be acquired, we should be given compensation according to the 2013 Act. If your lordship will confine to the prayer is only to quash the scheme, summary plan, and give a direction to the government to come up with a different scheme. I am just placing before your honor, your lordship, the opposite parties be directed to formulate a new scheme for the rehabilitation and resettlement of this one. So, in accordance with the provisions of the 2013 Act. So, he is not happy with this scheme. So, that is why, and so far as these claims, which he is now saying that this land should be acquired by the state government, we should be paid compensation as per the 2013 Act. We are holding the land for last 30 years. All these factual aspects and the so-called plea of adverse possession is cognizable in civil court, not in a writ jurisdiction. That is my responsible submission. So far as this scheme is concerned, we have given all good facilities to the occupiers who are occupying the government land, and this is for purpose of developmental work of the Mandira, the Samle temple. And just now I came across with a decision of Honorable Justice Jaswant Singh and MS Sahu in a similar matter in a Bhubaneswar land. He said that so far as government land is concerned, adverse possession you cannot claim as an honor. But I am not placing those things because that is beyond the pleading. Neither there is any pleading, nor there is any prayer in the writ petition that we are the rightful owner, we should be compensated in accordance with 2013 Act. Declaration of right title interest is only the authority is the civil court, not the writ court. That's all.
Yes, sir.
Lordship, I have challenged that scheme because as already I have submitted, your lordships, as I have challenged that scheme only. And my humble prayer is that that scheme should be in accordance with that act, and that the petitioner should get their legitimate expectation, and the due procedure has to be followed by the state. By virtue of a scheme, they cannot displace those persons and taken away their rights, your lordships, granted under the Constitution of India and different statutes, your lordships. By formulating a arbitrary scheme that is not in accordance with the articles of the Constitution, neither it is in accordance with the Act, your lordship. And there is a specific act for the acquisition. So even if they are residing over the government land since long, the government has to follow the due procedure. And by formulating an arbitrary scheme, they cannot displace those persons from their immovable properties, your lordship.
Yes. Who's appearing for the other petitioners?
Last item, my lord, last WBC 28562, my lord.
Yes.
It is not PIL, my lord.
All
But they are listed, in fact, listed before another bench, my lord. Since other matters pending here, that bench sent the matter to your lordship, my lord.
Correct.
My grievance is total difference, my lord. As because the government personnel and the temple management assured the petitioners, all the petitioners, 180 petitioners are, my lord. They are belongs to Shilu caste, Shilu tribe and backward classes, my lord.
All right.
They have residing over the land last 450 years, my lord. When they ask the petitioners for development of the Sambaleshwar temple and a plan was prepared according to the government, my lord, petitioner agreed with that, man, or their plan or program, my lord. And they have been evicted from that land, my lord, on pressure and giving false assurance that they will get adequate compensations, my lord. But they have taken to 5 kilometers away from the Sambaleshwar temple, my lord. And now they are residing there, my lord. The adequate compensation has not been given to them, and the transportation and other facility has not provided to them. They are, my lord, they are living in a distressed condition, my lord. For that reason, say they ventilated their grievance to the collector and the chief minister, my lord. But my humble submission, my lord, other persons are there, my lord. They are remaining within, my lord, 500 meters away from the temple, my lord. And the government provided them all facilities, my lord. And so far the petitions are concerned, no facility, my lord, to given to them, my lord. And when they raise their voice, my lord, some persons, my lord, threatened by police and taken to the police station, my lord. And police kept them for a night, overnight. The police station, if you raise your voice, then will smash all of you, my lord. But when the scheduled caste, scheduled tribe personnel having no other land, my lord, except that land, my lord, they are residing since their forefathers, my lord. The grievance has though they ventilated their grievance to the chief minister and also the collector, my lord, that has not been taken into consideration till late, my lord. And in the meantime, my lord, what happened? In the year 2021, my lord, the government, my lord, resettled the land in the name of some of the priests, my lord. And are published in their name. Subsequent that they have taken to the government land. All these things are there, my lord. My limited prayer is before your lordship, my lord. They came to this honorable court, my lord, get justice as because no adequate compensation and house rent. They have given that they will provide house rent for a period of 6 months, my lord. That has not done. They have not filed counter at least in my case, my lord. But what the poor people will go, my lord, except coming to this honorable court ventilating their grievance, my lord. When government silent about they not listening their grievances, and their duty earlier when the king brought them to the Sambalpur temple premises, their duty was, my lord, for drumming and cleanliness of the temple. By years, my lord, run, my lord, they have been residing there, doing other businesses, other works, my lord. Now they have no work with them, my lord. The lady members also there, my lord. And the collector also not listening, government also listening. For that reason, my lord, well, if this honorable court not, my lord, look with their grievances, my lord, then nowhere they will go, my lord. And those poor peoples, my lord, with much more, my lord, this honorable court, my lord, and their grievance may be taken into consideration, my lord. The adequate compensation, the government may be directed to give adequate compensation to them, my lord. That is my whole
My lord, so far as this case is concerned, admittedly, the petitioners have vacated according to the my learned friend. Same prayer, if your lordship will see at page 34, the prayer, they have also prayed that this sublay plan, the scheme which is liable to be quashed and some. And one thing I just heard from my learned friend's argument that their legitimate claim they are not getting according to the summary. Your lordship can direct the collector to ensure that all payments according to this summary plan should be paid to the petitioners. That your lordship can direct.
Other facility, transportation,
whatever the facility, according to the summary plan, you will get all the benefits. I can assure your lordship.
But that is our sole grievance, my lordship.
Oh, then
we have no objection, my lord, for development of the Sambaleshwar temple, my lord.
According to the existing policy, all facilities will be given to.
Item number 27. First case WPC number 16945 of 2022.
My lord, I am appearing in this case. I have filed this PL for implementation of this summary plan within a time bound manner.
WPC number 26247 of 2021.
Please, my lord, here the houses of the petitioners have already been demolished. Same prayer, my lord, the adequate compensation is to be given to us.
Next is already taken up. WPC 17004 of 2022.
Lordship, I am appearing for Mr. Pal. Lordship, in this prayer, there is a clear violation of Article 21 of Constitution of India. As it is the petitioner are staying in that place more than 30 years. And since then, they are not getting any compensation.
Last case already taken up.
I think except in case of Rakesh Suna, in all other cases, the petitioners have already been vacated.
Right.
Only in case some of the client of my learned friend is still occupying.
All right. All these petitions arise out of a similar set of facts concerning the rehabilitation and resettlement scheme for SAMLEI plan of the government of Orissa. Full stop. They are accordingly being disposed of by this common judgment. Paragraph. Some of the petitions have been filed as public interest litigation (PIL) cases. That is writ petition civil 16945 of 2022. Writ petition civil in 13241 also, right? Whereas certain others are by petitioners seeking relief for themselves. Paragraph. In writ petition civil 13241 of 2022, IA number 8432 of 2022 had been filed by the petitioners. No, 8432 was by you, right?
8432,
that IA.
Yes, 8432 IA.
Was by the state. No.
No.
It was by them only. It was filed as seeking interim relief and initially, while issuing notice in the said petition, on 27 June 2022,
June 2020.
an interim order was passed directing that no coercive action would be taken against the petitioners till the next date. Full stop. Thereafter, this IA was heard at length on 12 July 2022, and the following order was passed by this court. Reproduce the whole order. As far as the main writ petition was concerned, that is writ petition civil 13241 of 2022, the parties were permitted to complete pleadings. Paragraph. Agreed by the above order dated 12 July 2022, the petitioners in writ petition civil 13241 of 2022 filed SLP civil diary number 34732 of 2022 the Supreme Court of India. Full stop. The said SLP, in the said SLP, the following order was passed by the Supreme Court of India on 5th January 2023. Reproduce the order. Paragraph. This court has heard the submissions of Mr. Amitabh Pradhan,
Lordships.
learned counsel for the petitioner, and Mr. D.K. Manti, learned additional government advocate, appearing for the state in writ petition civil 13241 of 2022.
May I request your Lordship, we have filed a counter affidavit in this case. Your Lordship may kindly note.
Yes, yes.
On 11th July 2020.
Yes, yes. I'll do that. Full stop. Mr. Pradhan submits that the R&R scheme in question is itself without the authority of law, and it's contrary to the constitutional rights of the petitioners. Stop. According to him, the rights of the petitioners under Article 21 of the Constitution of India cannot be taken away arbitrarily by the state by formulating such a scheme, which has resulted in threatening the petitioners who have been residing in the area in question for over 30 years, forcibly and without any compensation whatsoever. Full stop. Referring to the rejoinder affidavit of the petitioner, it is contended that by virtue of the entries in the record of rights bracket ROR, which show that the petitioners have been residing in the property for over 30 years, the petitioners have perfected their title through adverse possession, and that cannot be taken away arbitrarily by the state. So reliance is placed on the decision of the Supreme Court of India in Poonaram versus Motiram, AIR 2019 SC 813. Paragraph. The second limb of the submission of Mr. Pradhan is that the scheme is contrary to the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013, bracket, the 2013 Act, bracket, as well as the Odisha right to fair compensation and transparency in land acquisition, rehabilitation, resettlement rules 2016, bracket 2016 rules, and the Odisha resettlement rehabilitation policy 2006, bracket 2006 policy. Full stop. He refers to the decision in Reserve Bank of India versus Peerless General Finance and Investment Company Limited, AIR 1987 SC 1023, and submits that in interpreting the above statute, the context in which it was enacted must be looked at. And if so looked at, it will be apparent that it applies to the case on hand, notwithstanding that the land sought to be, notwithstanding that the land is government land, land that the occupation of the petitioners is government land. So he asks the court to look at the definitions of single quotes land under section 3 bracket small p of the 2013 Act, comma, single quotes land owner under section 3 bracket R, and single quotes holding of land under section 3 bracket N of the 2013 Act. Stop. According to him, inasmuch as the petitioners have erected permanent houses on the land in question, they would fall within the definition of owners of immovable property, to whom the (2013) Act would apply. You see also definition of single quotes affected family under section 3 bracket small c bracket Roman small I of the 2013 Act. Full stop. Therefore, according to the petitioner, the 2013 Act would apply, notwithstanding that the land in question is government land. Full stop. Thirdly, he submits that the benefits under the scheme have not reached any of the petitioners, and they have a grievance that without any proper relief thereunder, they're being forced to give up possession of the lands in question. Paragraph. Mr. Ragada, learned counsel appearing for petitioners in writ petition civil 28562 of 2022, at the outset states that the petitioners have no grievance about the government's plan for redevelopment of the area and providing better facilities in and around the temple in question. We'll stop. His grievance is about the petitioners not being given the promised benefits of compensation and rehabilitation in terms of the scheme. Full stop. According to him, the petitioners in writ petition civil 28562 of 2022, who all belong to the scheduled castes, have been there for a substantially long period of time. And they are now left remediless on account of the forced eviction measures adopted by the government. Full stop. The petitioners in the companion writ petitions, counsel appearing for the petitioners in writ petition civil 17004 of 2022 have the same grievance as the petitioners in writ petition civil 13241 of 2022. And their submissions are in the same vein. Full stop. On the other hand, the sub-petitioners in the remaining petitions, that is writ petition civil 16945 of 2022 and 26247 of 2021, make a grievance about the improper implementation of the scheme. Paragraph. Replying to all of the above submissions, Mr. D.K. Manti, learned AGA, first drew attention to the counter affidavit filed by the state in writ petition civil 13241 of 2022. Where details have been set out regarding the goals of the Samalai plan.
Page 9.
Full stop. Inter-area, a comparison has been drawn between the benefits that could accrue under the 2013 Act and under the scheme in question to show that the facilities under the scheme in question is far better vis-a-vis the persons in occupation of the land. Full stop. For instance, as regards single court's cost of existing structure, the government is prepared to pay actual cost of the structure or 50,000 rupees, whichever is higher. Full stop. Likewise, provisions have been made for transportation cost, rental allowance, rehabilitation grant, and so on. Full stop. There is also provision for housing for those who have a house of not less than 50 square meters in plenty area. And in case a family opts not to take a house, to be given a one-time financial assistance of rupees 1,50,000. Of 3 lakhs, one-time building assistance of rupees 3 lakhs. Full stop. He held out an assurance on behalf of the government of Orissa that if any person is aggrieved by improper implementation or non-implementation of the scheme, despite being entitled to the benefits thereunder, the collector, Sambalpur, and other officers of the state would examine each such grievance and issue appropriate orders and directions for implementation of the scheme in such case. Full stop. He submitted that as regards the plea for adverse possession,
My lord,
no such plea was raised by the petitioner.
I have cited a decision, if your lordship can note it,
Right.
is High Court decision. Para 12 and 14.
Right. No such plea was raised by the petitioners in the writ petition itself, but only in the rejoinder. Full stop. He also relied on the recent decision of this court in Topan Kumar Behra versus State of Odisha, 2022 1 ILR-CUT 289,
Para 14.
where a plea of adverse possession vis-a-vis government land has been negatived by relying on the decisions in Karnataka Board of Waqf versus Government of India, 2004 10 SEC 779, Krishnamurthy S. Setlur versus O.V. Narasimha Sethi, 2007 3 SEC 569, and Ravinder Kumar Grewal versus Manjit Kaur, 2019 8 SEC 729. Full stop. He submitted that in any event, such a plea which should involve disputed questions of fact cannot be examined in writ proceedings, and the petitioners would be advised to work out their remedies in that regard in other appropriate proceedings. Paragraph. He maintained that this court had in its order dated 12 July 2022 already indicated a prima facie view about the non-applicability of the 2013 Act, to government land, which now stands affirmed by the dismissal by the Supreme Court of India of the SLP filed by these petitioners, challenging that order. Just one. The above submissions have been considered. In the order dated 12th July 2022, this court had addressed the issue whether the 2013 Act would at all apply. Full stop. There the court observed in paras 4, observed as under, just reproduce paras 4, 5, 6 and 7 paragraph. The court was not persuaded at this stage, persuaded that the 2013 Act would apply where the land sought to be acquired as government land. However, as pointed out in the above order, unless the government has invoked the 2013 Act, which it has not in the present case, the petitioners cannot possibly argue that the benefits flowing under the 2013 Act would inure to them. Full stop. Paragraph. On the other hand, the scheme appears to have been devised precisely to deal with the situation where there is unauthorized occupation of government land, and yet there is a real human problem of persons residing in such government land for a number of years, whose rights have to be addressed. Full stop. If one carefully looks at the scheme from that perspective, it is clear that many aspects of the rights to life and livelihood of the petitioners have been sought to be addressed by the scheme. Full stop. Which is why there is a provision made for rehabilitation and resettlement of those losing houses, either by granting a Gharabari plot of 60 square meters, bracket 650 square foot, having Rayati status, and in addition to the above, one-time house building assistance of rupees 3 lakhs. Full stop. Also, compensation is provided for loss of existing structure. Full stop. There is also a rehabilitation grant of 2,57,000 rupees to encroachers other than those in the slum areas. Full stop. Compensation is also provided for shopping units and to street vendors. Full stop. It does, there does appear to be merit in the contention of the opposite parties that the benefits provided under the scheme appear to go beyond those contemplated under the 2013 Act, if it were to apply. Full stop. Paragraph. Consequently, the court is not persuaded that the scheme in question either violates the 2013 Act or any provision of the Constitution of India. It appears to be a scheme to deal with the issues of rehabilitation and resettlement of those who are likely to lose their rights in land, which happens to be government land. Full stop. Paragraph. It is another matter about the scheme not being properly implemented. Full stop. There, the court places on record the assurance of the government of Orissa that individual cases of improper implementation or non-implementation of the scheme will be promptly addressed by the officials and sought to be redressed within the framework of the law. Full stop. Paragraph. Turning to the plea of adverse possession, the court would like to reiterate its decision in Topan Kumar Behra versus State of Orissa, Supra. About the heavy burden that lies on a person seeking to assert such a right. Such a right can possibly be proved only in proceedings before a civil court. Even in the present case, documents, that is the entries in the ROR, sought to be relied on by the petitioners in Writ Petition Civil 13241 of 2022 will have to be proved in a civil court in a civil suit filed by them, asserting such a right. Full stop. The writ proceedings are not appropriate for that purpose. Full stop. It is clarified that the dismissal of the present writ petition by itself would not preclude the petitioners from seeking to establish their rights in other appropriate proceedings in accordance with law, and if it is so permissible in law. Full stop. The general grievance of the petitioners, as regards the general grievance made by the petitioners about their individual grievances not being addressed, a direction is issued to the collector that if any such individual representation is received from any of the petitioners, which representation should be made to him not later than 3rd April 2023. Then after examining each such representation, and preferably after giving hearing to each of the petitioners, making such grievance on dates to be informed to them at least 7 days in advance, he will pass reasoned orders, preferably within a period of 3 months thereafter. Full stop. If agreed by such orders, it will be open to the individuals concerned to seek appropriate remedies in accordance with law. Full stop. The writ petitions are accordingly disposed of with the above directions.
My lord, may I pray your lordship to communicate this order to the collector for compliance?
Copy of this order be sent to the collector forthwith. After lunch.
Lordship, there is a gochur land in the mid of the village, village Kujaholo. That is a cattle grazing land, and the particular land is using for the.
All right, the petitioner's representation and action to series shall be examined by the Tahsildar, Jajpur, and after notice the petitioners and giving them a hearing. The reason order should be passed there are not later than 10th April and be communicated by 17th. The court clarifies it is not expressed.
Item number 29.
Please, Lordship, item number 29. A permit to withdraw unliberty
Liberty to file a better petition. All right.
No, item 64, your lordship has died. Mr. Lohani is to 60.
Item number 64.
Mr. Lohani.
Good afternoon, sir. This is Sushil Lohani, Principal Secretary, sir. We have already taken a decision, sir. We have allowed transfer of land from Panchayati Raj to Rural Development Department, sir.
Okay.
And affidavit has been filed, my lords.
All right.
That is on 21st January 2023.
All right. Mr. Lohani, the Secretary of the Panchayati Raj Department, Principal Secretary to the Government of Orissa Panchayati Raj Department, Panchayati Raj and Drinking Water Department is present online, and he has also filed an affidavit dated 21st January 2023 enclosing the letter dated 20th January 2023 issued by the director of his department to the collector Bargarh, conveying the decision of the government to allow the transfer of road. Just take from that highlighted portion at page 12, that affidavit, of 5.5 kilometers from the PR and DW department to the rural development department. Full stop. The collector has been directed to take necessary steps for transfer of the road at his level as per the existing rules. Full stop. Anything further needs to be done?
No, nothing.
All right. Where's the counsel of the petitioner? It's not come today. That means the matter.
Now the R&B division is to pursue the construction or tender work, whatever it means.
Yeah, the R&B department will now take steps to float a tender for completion of the process of road of a motorable road in a time-bound manner. Stop. Should we issue a notice to the R&B department for that purpose?
The R&B department has already filed counter affidavit. There they have stated that the land has not been transferred from the panchayat. From that government of the counter affidavit, your lordship has.
I know. If there's any grievance in that regard, it will be open to the petitioners to seek appropriate remedies in accordance with law. The petition is disposed of. All right. Thank you, Mr. Lohani.
Thank you, sir.
Item number 30.
Item number 30 and 33, Your Lordship, there is a defect of not service of copy, Your Lordship. I am serving the copy today. Lordship, kindly keep it to 1 week after.
All right.
I'll receive the copy.
All right. List on. Is there any urgency in the matter?
No, Your Lordship, there is no urgency.
20th March, 20 March.
Obliged, Lordship.
Defects be removed. Yeah.
Item number 31.
The dispensing with
my learned friend has filed a counter in this matter. I humbly pray if a learned friend could give me a copy, so I can file a reply to that.
All right. Rejoinder to be filed for the next date.
Lordship's like fixing.
List on 28th August.
20. Can't it be sometimes the end of July?
No, no, it's okay. Yes.
Item number 32.
Obliged, All
right.
My lords, 32, challenging the first appellate authority order under GST Act, my lords.
You pay 10%.
My lord.
All right.
Copy not.
All right. Notice, he accepts notice. Reply within 8 weeks to join for the next date. In that IA, you say it is stated that 10% of the tax demanded has already been paid at the first appellate stage. Will stop subject to the petitioner paying 20% of the remaining demanded tax within 4 weeks. No coercive steps will be taken against the petitioner during the pendency of the writ petition. The IA is disposed of. The main matter is a list on 22nd August.
Item number 34.
May please. Lordship, in this matter, already last time I have prayed for time to remove the defects. The defects are minor. If your lordships permit me to place the matter or remove the defect. Otherwise, I will place the matter.
Defects are not serving copy.
No, I have served copy.
Need copies. All right. You tell us what the matter is for.
Lordship, in this matter, already at page 27 and 28, your lordships. Sorry, 25 and 26. Final audit report was given to me, specifying determining the amount sought paid. And white page 27 and 28, I have complied that and paid the tax amount. Page 27 and 28. This is for financial year 2014 and 15. Again, your lordships, for the financial year 2016 and 17, final audit report was given to me at page 31 and 32. And that the very amount was also paid at by page 34 and 35. But after that, demand cum SOCOS notice was issued and personal hearing was there. I submitted all my documents, but without taking into consideration that they have passed the order in original.
But that's an appealable order.
Yes, lordship. But only my grievance is when I have already discharged my liability according to departmental audit. This is not my audit. And again, there is a bar at page 57, your lordships. Their own notification. No, not page 50. That is page 58, your lordships. 4.3.6. May I please, lordships? The assessees who have been selected for audit or have been audited recently in the past 3 years should not be taken up for detailed scrutiny. However, the Chief Commissioner may direct detailed manual scrutiny of an assessee's return who has paid service tax, cash plus VAT, more than 50 lakhs. But here it is only 13 lakhs. In certain specific cases, in no event should an assessee be subjected to both audit and detailed manual scrutiny. Already I am subjected to audit. I have discharged my liability. Again, there is scrutiny.
Why should we interfere straight away now? You can file an appeal.
Let's say already when my no liability is there, urge for their audit. And only basing upon that only, I was demanded a very...
we still have to examine the merits of the matter.
Yes, lordship. Only let my friend take instruction on that, whether I have paid or not.
No. After your payment, this showcase notice was issued.
Yes, they have not taken into account that. But what they have not taken into account my payment receipts. They have not reflected in that order also. They have paid something, what is the final audit report and what is my liability on that particular period, 2014, 15 and 16, 17.
Turn to page 48.
48.
48. The order in original. It is an admitted fact at 5.3, your lordship.
Correct.
The admitted fact is that he has submitted those audit reports, my lord. Then your lordship come to 5.4. From the records presented before me, I find that the noticee at no point of time have denied, refuted, challenged the allegation framed under the so-called notice it implies that the noticee admit the allegations made against him. In absence of any documentary evidence, I find it difficult to exonerate the noticee from the charges framed against them. However, the noticee in their letter dated 28 August 2020 has enclosed only the audit observation report in order to examine the veracity of the contention of the noticee. This office by letter even number such and such dated 19 February 21, followed by reminder even letter dated 31 March 2021, requested the GST and Central Excise Audit Commissioner Bhubaneswar to intimate this office whether the comprehensive audit, including reconciliation of the books of accounts of the noticee, has been done. The audit commissioner did not submit any report. By this office letter, even number 4785 dated 8 March 2021, the notice was requested to submit a copy of the audit profit and loss accounts, copy of the 26S statements, reconciliation statement of income tax between profit and loss account and ST3 return, copy of the ST3 returns, and copy of the all work orders along with the sample invoices against which the service tax exemption has been claimed. The noticee didn't submit any document. He has never submitted any document save and except that audit report.
Why is that?
Your Lordship, kindly have a glance at page 47. At clause 3.0, there is specifically written in response to the aforementioned so-called notice, the noticee did not submit any written reply, but documents have already submitted. And at para 4.0, personal hearing was there. Following the principle of natural justice, such an opportunity of personal hearing was given to the noticee on 28 2020. Personal hearing was held on 28 2020. These persons were appeared for personal hearing. They gave Hajira dated 28 2020, enclosing audit of justice report.
Only that report they submitted.
Already 26 AS and all these are given on that day. Personal.
Not all. Only the audit observation report you given.
That was recorded only this, but everything I have submitted. And so far as this circular, their own notification is also considered concerned. They have never satisfied their own notification that 4.3.6, in spite of their own notification that in no event.
Tell us if all the documents are there or not.
I'll take instruction.
One of the allegations in the present petition is that despite the petitioner having submitted all the documents in its possession at the time of personal hearing, pursuant to the show cause notice dated
8/11/2019.
8/11/2019, issued by the Joint Commissioner.
36 page.
Additional Commissioner,
Yes.
GST and Central Excise, Bhubaneswar Commissionerate, the adjudication order dated 19th April 2021 does not reflect the filing of such documents, and on the other hand states erroneously that no documents were submitted by the SSC. It is further pointed out that the amounts paid by the petitioner pursuant to the audit observation reports on 2 occasions were not taken into account in the adjudication order. Paragraph notice, Mr. Mishra accepts notice on behalf of opposite parties 1, 2, and 3. A detailed paragraph reply should be filed within 8 weeks to join up for the next date. What about the interim order? Is there anything? Because this is already a 2021 order. Nothing seems to have happened.
They are only issuing notices to
just say notice on the side. That's enough.
Okay.
List on 17th August.
Item 35.
May I please, in this item 35, my friend learned Advocate Mr. Mahapatri is appearing.
My lords, I'm appearing through VC, my lords.
At phase 59, already discharge certificate was issued in my favor because my employer has already deposited the amount. And similar cases also already adjudicated by your lordships, but I don't have that order.
Yes, Mr. Mop.
My lords, this is a case of a goods transport agency. By virtue of reverse charge mechanism, the liability is on the petitioner.
No,
and the petitioner cannot liability. My lords may see, by virtue of reverse charge mechanism, the liability is on the petitioner who is a good transport provider.
Yes.
She is submitting that because the service tax liability has been discharged by the
employer,
by the receiver of the service. That's the reason there is no liability to pay service tax on her part, which is totally contrary to the provisions of section 68 of the.
She says there are other orders passed by the court in support of the petitioner. Are you aware of that?
Well, I am not aware. I request my.
All right. At the request of counsel, the petitioner who wishes to cite certain judgments in her favor, list on 18th April.
Oh, blessed.
Grateful.
Item number 36.
Item 36, I pray let it come next week because I have filed a miscase. Because now in the meantime, they have attached my back account. So that's why I have filed a miscase for that reason. So let it come next week along with that miscase.
Lordship, it is the assessment order under section 63 which is applicable to your lordship. After assessment, your lordship, since payment has not been made, consequential attachment has been done.
You will file an appeal.
Milord, I will point out, Milord, let it come, Milord, I will point out. Because, Milord, they have issued me under notice under section 63, Milord. Your lordship can have a glance that 63, Milord. The 63 is that, Milord, whenever the person having no registered dealer, Milord. But so far this petitioner is concerned, Milord, his registration is valid and he has been filing.
That's all on merits, sir. That's all on merits. And can't you challenge the assessment order?
And your lordship, there is, let it come next to Milord, I will point out. And they have, Milord, demanded a sum of rupees, Milord, 1 crore when I am a, Milord, contractor.
That's all on merits. Again, we are only on merits. We are talking your alternative remedy.
Milord, the alternative remedy, your lordship knows that in case of Radhakrishna industry also, Milord, when that is act itself is without jurisdictions and the person is, Milord, is without any notice and without, Milord, giving any opportunity to be hearing, your lordship will also find that this person was never noticed. That notice was in Milord.
You have come in a writ petition, so now you know whose liability it is. If it is not your liability, you would not have filed this writ petition, sir. Milord, you acknowledge it is your liability. That's why you are coming here.
Milord, so far liability is concerned, Milord, I have already paid those taxes.
What you can point all that out in the appeal.
And so far appeal is concerned, Milord, though, Milord, I am not liable to pay, Milord, all those taxes because I have to pay, Milord, 10% of that as per 107.
Whereas this is only
Milord, they have assets.
So this is only 6.5 rupees.
Milord?
This is only 6.5 rupees. That is 10%. And
economics. Not
we also understand these economics very well.
No, Milord, not Milord, economics, but thing is, Milord.
Only economics, sir.
No, Milord.
Only economics.
Milord, the point is that, Milord, whenever the person has not executed any work of that nature.
All grounds. You'll get all grounds and even more grounds. After you leave this court, you might think of more grounds also. Milord. All these grounds, those grounds, everything.
Milord, right. But Milord, I have to pay, Milord, though I have not liable to the tax.
So ultimately it comes to 6.5 rupees and that 10%. That's all. That's the difference.
Milord, 10% is Milord, I have to also. That's
and counsel the petitioner seeks leave to withdraw the special petition with liberty to file an appeal in accordance with law against the impugned assessment order. If such appeal is filed not later than 10th April, accompanied by an application of condonation of delay, explaining the pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority. Court clarifies it is not expressed in the matter. He has not listed it also, so now it won't get listed.
Because your lordship can have a glance, Milord, what is their act also. That 63 notice is also, Milord, not applicable to me.
All right.
Item
because
37.
that notice itself is bad. That's why, Milord, I am pointing out.
All.
That is Annexure 1, Milord.
All right.
37.
37 and 38.
Yes.
There are some defects. I will remove the defect within a week.
All right.
Copy note, sir.
I am giving you.
List on 10th. No, not 10th. 14th February. Defects we removed in the
Item number 39.
None appears dismissed.
Item number 40.
Your Lordship, item 40 and 40 not pressed yet.
Not pressed.
40, 41.
Yeah, 40 and 41.
Item 42.
40 and 41, Your Lordship.
Item number 42.
42 in the meantime, order has been complied with.
Writ appeal is dismissed as having come in practice.
Item number 43.
Please, Your Lordship. My lord, my senior is ill. Kindly let it come by tomorrow or any other day as you wish.
Where is he? Where is your senior, sir?
My lord?
Where is your senior?
The senior is ill, my lord.
Calls for the appellant stated to be ill. List on the 1st August.
43. Item number 44. Item 44.
None appears dismissed.
Item number 45.
May I please, Your Lordship? Relating to family pension. Now, family pension has been turned down in view of the order of dismissal passed by the note signatures. Well, fact of the son was the chowkidar under the opposite party. After rendering total period of service, he had rendered 16 years, 5 months, 22 days, 7 years. Now, 7 years, 1 month and 10 days have been excluded from the service on the ground of the extraordinary leave. Intervening period, some intervening period has been excluded. Because family pension has been rejected on the ground that not eligible for family. Less, he has also answer 8, page 24. With reference to your above letter, it is stated that since Vasudeva had rendered less than 10 years of qualifying service and was compulsory retired on disciplinary ground, he was eligible to receive service gratuity according to his father daughter entitled government pension. Answer 8, page 24. Second, answer 9 also same rejection order. Intervening period, 7 years, 1 month has been excluded from the total. He has rendered 10 years eligible. He has rendered 9 years, 4 months.
Problem is it's less than 10 years, sir. The problem is it's less than 10 years.
But decision of intervening period can be counted. Your Lordship, intervening period counted for the purpose of pension retirement. I have a settlement. I have about also paragraph 10 if we counter some decisions.
Which decisions?
Paragraph 10 of my read petition. Paragraph 10, Your Lordship, intervening periods can be counted also for the purpose of pension or intervening period.
See, that period of 7 years, 1 month, 10 days has not been sanctioned.
Well, he was entered into service in the 88 out of the state. He transferred from the Odisha 88, 98. After 10 years out, 10 years service, he has entered out of state. Extra all Your Lordship, they have given the Your Lordship in the chart.
Sir, just come to page 31. This is all extraordinary leave. The 7 years,
Yes,
1 month, 10 days. It's all leave, sir. Never been sanctioned. Leave that is not sanctioned. How can you count for pension, sir?
Payment salary has been given in.
The challenge in the present appeal is to an order dated 26th April 2016 passed by the single judge dismissing the appellant's writ petition civil 11139 of 2010, whereby a mandamus had been sought to the respondents to grant the petitioner pension by including a period of 7 years, 1 month and 10 days, which was in the nature of extraordinary leave, as part of the total length of service for the purposes of pension. Paragraph. It is seen from the impugned order that no prior sanction had been granted to the petitioner in favor of the petitioner for the long period of absence from duty, that is 7 years, 1 month, 10 days. Full stop. In the absence of the said leave being unauthorized absence being sanctioned, the question of including the said period for the purposes of qualifying service for pension does not arise. Full stop. Paragraph. Having perused the impugned order of the single judge, the court is unable to find any legal infirmity that calls for interference. The writ appeal is dismissed.
Item 46.
None appears dismissed.
Item number 47.
Well, at item number 47, item may be tagged with writ appeal number 373 of 2020, my lord.
No, what is there is 373 only. What is listed today is 373, madam.
My lord, for orders for condonation of delay, my lord. And for removal of defect, my lord.
No, what's the delay?
83 days.
83 days. What's the matter about? Tell us.
My lord, I pray for an adjournment because my senior is out of station. I pray for next week at least, my lord.
It's on 28th June. Defects were removed.
Item 48.
Your Lordship, on behalf of Mr. Bahali, matter has become infectious.
Dismissed as infectious.
Item number 49.
There are some defects. I will remove the defect, let it come after 1 week.
Delay.
158.
Delay you explained, sir.
Pardon, man.
There's a delay of 158 days.
To obtain the certified copy, the order was passed on 27/2/2020. The petitioner applied for the certified copy on 28/2/2020 and received the same on 4/3/2020, my lord. Because of the COVID-19, we could not file.
And then what's on merits?
The brother of the petitioner, namely Pradeep Kumar Panda, challenging the transfer order dated 27/10/2014, filed original application before the State Administrative Tribunal, and on 31/10/2024, Tribunal directed the collector to consider the repentation within 3 weeks. Till then, no coercive action. On 31/10/2024, on the same day,
24 May.
sorry, 2014, my lord. On 31/10/2014, on the same day, that Pradeep Kumar Panda filed a CL application before the headmaster, and that CL application was granted. That application was granted in Annexure 1, and on the next day, on 1/11/2014, another CL application was applied by Pradeep Kumar Panda. That was also allowed. And subsequently, when another CL application was filed on 7/11/2014, the headmaster said that since you have already been relieved on 31/10/2014, your application will not be acceptable. And the brother of that Pradeep Kumar Panda, who is the petitioner, applied under the Right to Information Act to obtain that CL application, which was allowed on 31st/10/2014 and 1/11/2014, but that was not supplied. On this period, that Pradeep Kumar Panda received the salary, but the headmaster says that since on 31st/10/2014, he was relieved from the service after the transfer order, even if the interim order was passed by the state administrative tribunal, that application is not received by the headmaster. But these two applications were not supplied, and regarding this, the commissioner as well as the honorable single judge has not whispered a word regarding my application, even if they have paid the salary from the said headmaster for these periods.
No, but your prayers are something else, sir.
The order of the commissioner under annexure 8 and 9, order passed in WPC number 510 of 2019. In annexure 9 at page 32. In the said order, even if I have filed annexure 1 and 2, saying that this leave application of the petitioner was CL application was allowed, and the headmaster says that you have been relieved on 31st/10/2014, and salary has been paid by the said headmaster. That aspect was not taken into consideration by the single judge. And only he has said that since all the documents have been supplied, writ application is dismissed.
Correct. Subsequent information relating to leave applications of Pradeep Kumar Panda, assistant teacher, so and so on 31/10/2014 and 1/11/2014.
Yeah, it was not received.
The same had not been received by the headmaster of the school.
Correct. It's to a judgment dated 27 February 2020, passed by the learned single judge, dismissing writ petition civil 510 of 2019, filed by the present appellant, in which a direction was sought. No, in which the order dated 6 September 2018, passed by the State Chief Information Commissioner, in second appeal number 363 of 2016, was dismissed. The appellant also sought a direction for levy of penalty of ₹250 per day between 9th December 2015 and 12th May 2016. On opposite party number 4, that is ex-headmaster Kathapal UG UP school, and take disciplinary action against him for supplying a false and misleading information to the petitioner. The impugned order notes that after the appellant made an application form A, the requisite information was called from the headmaster of the school, which was then obtained and handed over to the appellant on 8 December 2015. Full stop. Paragraph. Further information sought by the appellant by an application dated 21st July 2016 was also handed over to him personally on 22nd August 2016. What was only withheld was the subsequent applications relating to the leave applications of Pradeep Kumar Panda, a former assistant teacher. Full stop. This information was withheld because the said Pradeep Kumar Panda got relieved from the school on 31st October 2014 itself. Paragraph. In that view of the matter, the court is unable to find any error having been committed by the State Information Commissioner, rejecting second appeal number 363 of 2016 on 6 September 2018. The writ appeal is accordingly dismissed. These
they have said that CL application 31/10/2014 and 1/11/2014, this same had not been received by the headmaster, but I got the salary for this head period.
All right.
Item number 50.
Appearing to appeal number 1.
Item 50.
Delay.
52.
Page 70, page 77, that is the UGC matter. That has been disputed by relying that judgment of Alok Mishra that has been stayed. And I have verified the website that has been tentatively fixed to 14th February.
It is stated that the matter in the Supreme Court is fixed for 14th February.
And there is no limitation in this case.
2023. List on 22nd August.
51.
Item 51 and 76, 77, 78, 79. All are UGC matters.
Same order.
Item number 53.
Limitation.
So that means 3 days delay, I'm filing a petition.
All right.
3 days delay.
All right.
The short question for Lordship is that
asking to
yes, question for Lordship that the petition services was terminated without following the procedure of law and not contrary to all principle of local justice. Consequently, single judge caused it and directed for instatement. Lordship will gate from page Annexure 3. I will not waste your Lordship. Page 15, Madam. On the cumulative effect, the upwards have passed the reasons the impugned order Annexure 1, dated 1/10/2019, that is the order of termination, is liable to be interfered with. Accordingly, same is quashed and set aside, and quashment of the impugned order dated son shall not include the opposite part to subject to another proceeding because of the RDC order passed the order. Thereafter, I file another application where ID is for the purpose from the date of termination till reinstatement. Annexure 5, page 17. So my contention is that since there was no laches on the part of the employee to discharge the duty, minimum salary should be granted to him. That is my limited submission for Lordship. Let's get on to Annexure 5, page 17. That is the impunity for Lordship by passed with the Honorable Single Judge, that they have directed from the date of joining and grant the salary. So even if my service is not regularized now, my pay fixation is not able to made.
No, but he's asked that.
Page 17, Madam.
That's right. It goes without saying that since the petition has been re-engaged, he's entitled to salary.
My lord, pursuant to quashment of the order, my lord, I was reinstated on 15/9.
All right.
But 19 I was removed from service. That was caused, my lord, as an annexure 3. So what I'm trying to confirm for lordship is that from the day I was removed till the order was quashed, I'm entitled to the salary. Otherwise, my lord, the service period cannot be also regularized.
No, notionally you won't get payment, but for notional purposes it will be treated as no break in service.
And there was no laches on my part to discharge the duties.
No,
And the
that's
justice
okay.
Mishra
No work,
met
no
my
play
lord,
applies, sir. So no work, no play
no
applies.
place, yes, but like bow down to lordship's view, my lord. But there are authorities, even Apex Court recently heard by my lord Justice Deepak Mishra said that where a person was not allowed to discharge the duties by the employer or illegally not allowed to discharge, entitled for the salary. That's my limited submission. And if my salary, my regulation of services and pay fixation could not be made because of this period, and no payment has been made for the period from 1/10/2019 to 15/9/2020.
But that doesn't have to wait for this. You was re-engaged only on 15 September.
I was reinstated by virtue of lordship's order and annexure 3.
Correct.
Then, my lord, but the period for which from the day I was removed till 15/9.
That arrears you won't be paid, sir. You see,
Is
the
not
arrears
paid.
taken on record. The delay of 3 days is condoned. The challenge in the present petition is to an order dated 5th November 2020, passed by the learned single judge, disposing of writ petition civil 22161 of 2020, filed by the present appellant. The above writ petition was filed with the present appellant, praying that his salary, the block education officer Badrak should be directed to release the petitioner's salary with effect from 1st October 2019 and accord all consequential benefits. Paragraph. The learned single judge is an impugn order noted that petitioner was re-engaged only on 15 September 2020 and therefore be entitled to salary only from that date. Paragraph. Mr. K.P. Mishra and senior counsel for the appellate submits that the dismissal of the appellant from service by the BDO, by the order dated 1st October 2019, was in gross violation of law, and that is how it was set aside by this court it was stayed by this court.
Page 15, ma'am.
No, it was set aside by this court by the order dated 27 January 2020. It is contended that the BDO did not accept the joining report of the appellant, and due to such inaction, she was not able to join. Till September 2020. Paragraph. Before the learned single judge, the BDO filed an affidavit pointing out that the petition had been reinstated by the order dated 15 September 2020. And therefore, there was a question of paying arrears of salary for the earlier period. paragraph. Having heard Mr. K.P. Mishra and senior counsel for the petitioner and Mr. Mahapatra and counsel appearing for the SNME department. The court observes that although the appellant may be justified in contending that he was prevented from working for no fault of his for the aforementioned period, the fact remains that on the principle of no work, no pay, the petitioner cannot be expected to be paid the arrears of salary for the said period. Stop. Nevertheless, all the incidental and consequential benefits of reinstatement, including notional seniority being restored, including seniority and other benefits being made available to the appellant on the basis that there would be no break in service, ought to have been ordered with the learned single judge. Full stop. Paragraph. Accordingly, the impugned order of the learned single judge is modified by directing that for the purposes of promotion seniority, it will be taken that on notional basis, the petition has been reinstated with effect from 1st October 2019, although the petitioner would not be entitled for arrears of pay from that period onwards. The appeal is disposed. For the purpose of seniority promotion and fixation of pensions.
Item number 54.
May I please your lordship, item 54, my lord, and appearing on behalf of my lord. In this writ appeal, challenging the order dated 9/11/2020, passed in WPC number 27431 of 2020, my lord, which is in the annexer 2, my lord, page 41. The relevant page is the page 43, my lord. Decision taken to look into the grievance of the petitioner and take a decision as appropriate involving opposite party number 7. I am the opposite party number 7 in the writ petition, my lord. Taking into consideration of plea taken in the writ petition, the document there too within a period of 4 months, my lord. Well, this order was passed, my lord, without taking into account, my lord, the petitioner in the writ petition. They have got no locus standi to challenge my appointment, my lord. And they have also not taken into, in the complaint, they have not taken into consideration any of the documents also they have not. Well, on the grounds, my lord.
By now, this order would have worked itself out, sir.
My lord, I have an interim order, my lord. I have an interim order, my lord, in writ appeal 738, I number 1623/2020, dated 8/1/2021, my lord. That the...
All right. What do you say? Have the others been served?
That is the allegation is that at the time of her appointment, he was 16 years and prosecuting her study in a college, in that college.
Oh.
Your lordship can find it from page 33. That is in Odia, my lord, that I can. 33
is in Odia, correct.
Yes, but that's, I can, lordship, serial number 1. Runulata Pradhan library attendant. At the time of appointment, she was underage only 16 years and 5 months and was and her post was approved without verification of her documents. At that point of time, she was also prosecuting close to in regular course. And her date of birth is 25/3/1977. This was the allegation, and not only against her and some other persons. Accordingly, your lordship had directed to consider the representation. No order has been passed, and
Because of stay order, we have not passed any order.
No, please. That doesn't mean you don't consider the representation.
Yes, Mother. But your lordship has stayed it on 8/1/2021.
Counsel for the state informs the court that only because a stay order was passed by this court on 8 January 2021 in the present appeal, the state has been unable to proceed to consider the representation made by the appellant.
Made by the opposite parties, my lord.
Sorry, representation made by the opposite parties. In terms of the judgment of the learned single judge.
Yes, my lord.
In terms of the judgment of the learned single judge. Stop. The court is of the view that, as ordered by the learned single judge, there ought to be a proper inquiry. Preceding any decision. This is only 7 to 11. Which of them has come in appeal here?
That's opposite party number
7.
My lord.
Regarding opposite party number 7 in the writ petition, that is the appellant here. Full stop. It may be noted here that one of the grounds on which the appointment of the appellant is challenged is that she was only around 16 years old.
My lord, 16 years and 5 months.
5 months at the time of her appointment. Without expressing any view on merits, the court, while vacating the impugn order, clarifies that the inquiry pursuant to the order of the learned single judge will be held uninfluenced by any observation of the learned single judge on merits. Full stop. It should be with the full participation of the appellant and anyone else against whom it may be directed. Full stop. The inquiry be completed in accordance with law pursuant to the directions of the single judge within a period of 6 months from today. The appeal is disposed of.
My lord, my appearance may for OP number respondent number 4.
All right.
I am for the respondent 1. Item 55.
55, no instruction.
No instructions dismissed.
Item number 56.
None appears dismissed.
Item number 57.
Your lordship, may please, your lordship, it's covered by your order. Your
Okay.
lordship may kindly turn to the order dated dated 9th December 2014. Your lordship, the registry is directed to tag the case along with STRV 35/2005. 35/2005 has already been decided. This is that meter rent, electric meter rent against the revenue.
All right. In view of the decision dated 10th April 2019 of this court in STRV 35 of 2005, no, but the other side has been served here.
Your lordship, this case, my learned friend.
Now, once it's admitted, you are appearing for the other side.
Yes.
What is your submission? They say it's covered in their favor by this 35. Are you aware, sir? Your You're not aware?
No.
All right. All right. See, the challenge in the present petition is to the present revision petition by the department arises out of an order dated 19th September 2013, passed by the Orissa Sales Tax Tribunals. Right. Dismiss it. Department's appeal. Essay number 112 of 2008-9, which in turn arose out of an order dated 31st December 2007 of the Additional Commissioner of Sales Tax, Assistant Commissioner of Sales Tax, bracket ACST Sundargarh Range, in AA number 39, bracket RL-1 of 2007-8. Full stop. The question that arose for consideration was whether supply of electricity meter to the consumer on payment of higher charges would amount to sale within the meaning of the Orissa Sales Tax Act 1947. Paragraph. That question stands answered in favor of the SSC and against the department by the decision dated 10th April 2019 of this court in STREV number 35 of 2005. Full stop. It may be noticed here that while admitting the present revision petition by the order dated 9th December 2014, the present revision petition is asked to be listed along with the aforementioned STREV 35 2005 paragraph. In view of the above decision dated 10th April 2019 of this court, the present revision petition also has to be decided by answering the question in favor of the SSC and against the department. Full stop. The STREV is accordingly dismissed. Right. That's already allowed. That's already allowed.
Your Lordship. Your Lordship, the next case is
Item
also
58.
covered. The next case is also covered, that cattle feed, Your Lordship, chokered cattle feed, non-scheduled goods, Your Lordship. The question number 3 and 4 have been admitted.
Right.
So when 4 is covered, so 3 is consequential when it is non-scheduled good, Your Lordship.
All right. You say in view of the decision of this court dated 2nd August 2022 in STREV 31 of 2011, bracket State of Orissa Services, Geeta Shri Industries. Orissa something. Yeah. The present revision petition is dismissed.
Item number 59.
My lord, just now I have received the counter from my lord senior.
Corona period, I have been finding I have sent the copy by registered post on 1st September 2021. But now since my not friend he has not received the copy, I have started another copy of the counter application.
May I pray my lord 1 week to file the rejoinder of that counter, because the question of penalty and the license fees in question, where the GST has been introduced in the year 2017, but it was levied and since 2000 till 2019. That is the only question. My lord and senior has filed the count, served the copy of the counter just now.
Okay, rejoinder to be filed for the next date. Interim order to continue. List on 29th August.
God bless.
This case may kindly be taken up along with the disposal case number 12379 of 2010. Because same cause of action, earlier interpretation has been filed, that order of this honorable court has been flouted by my lord. Then, therefore, that case may kindly be listed. Start along with this. WPC number 12379 of 2010, this was upon 15/5/19.
All right. The record of
12379.
2019. Of 2010, we requisition for the next date.
Problems.
Item number 60.
Competition of right?
It's my lord. I have challenged for the non-selection of the petitioners under the award, Design Innovation Award 2016. And that award has been filed under Annexure 1, my lord. What is the award? In 2016, government declared for award. Category of award is page 15, my lord. This came. So, in category of award, that is Shilpi Guru, National Award, National Merit Certificate, and Design Innovation Award. So, the petitioner was applicant to the Design Innovation Award. And so far as award is Design Innovation Award is concerned, that is page 17, column 4.3. Design Innovation Award. This award would be given on co-creation basis to both the designer and artisan. The age criteria and experience of the artisan would remain in the same as per national award, that is 30 years and above, having 10 years experience. And clause 4.3.1, the award contains the Design Innovation Award will be rupees 10 lakh, 8 lakh, and 6 lakh for first, second, and third category to be shared equally between the designer and the artisan respectively. So in this contest, the petitioner applied, but no result was declared. What happened is for his entry. That's why he earlier approached this honorable court, and this honorable court issued notice directed to the authorities to place the matter, and they did not respond. That's why the order was passed. I have abhorred that order in my writ petition, page 6, the earlier order. May I read, ma'am?
All permissions granted, sir.
Ma'am. That order dated 12/11/2019, Heart Sri Kailash Chandrakar London Central Government Council for the Union and India, Part number 113. By way of this writ petition, the petitioner aspired for a direction to the opposite parties to declare the result of the Design Innovation Award 2016 within a stipulated period. On perusal of record, it is seen that this court.
Anyway, they asked the award to be declared. Result to be declared.
Declared. So, in pursuant to the order of this honorable court, they issued the first time. They issued the letter to me. That is Annexure 3, page 25. The subject declaration of result Design Innovation Award Himanshu Parida before Honorable High Court of Orissa, Kotak, dated order dated 11/1/2019, writ petition number 8. This is referred to your copy of order received by this office. In this connection, I am directed to inform that as none of the entries for Design Innovation Award for the year 2016 have been found worthy, the headquarter level committee headed by the DH has not recommended any entries for consideration of Design Innovation Award, and the same has been recorded in the minutes of the central level selection committee meeting held on 16/1/2018, as well as it is paramount to mention here that as per the procedure for final selection of a entry, the same is needed to be gone through 3-tier committee consisting of the eminent experts in the respective field, and the composition of 3-tier committee are as follows. So there is that has been already reflected in the order answer 1 the scheme. There is a 3-tier system for its selection. First is the regional level, second is the headquarter level, and third is the central level. So now the central level have given the reply saying that no recommendation have been brought from the headquarter level regarding the entries. For that, they have not selected for design of innovative method. So in this regard, they have also communicated that annexure 4. So I have, then my lord, I have.
No. You want this court to issue a mandamus to them to give you the award.
That is not the, my lord, I am not the award's respect, but they have not taken to my consideration what happened my entries. They have not assigned any region, anywhere. Why they have not recommended?
Why should they give reasons?
I am not saying that.
Ask those reasons.
That is, they will select.
Why should they ask for those reasons?
I am not in that whether they will select or not, whether they will not. Because when I called for the result in the RTI, they should have assigned. So we will not select. So
This
that
is just
they have
an award,
not,
sir. This is just an
my
award.
lord, they have nowhere.
This is not an exam that you sat and wrote and you want to know your answer sheet evaluation. It's not that kind of a thing.
No, it is not the question of answer sheet, but they have not evaluated my answer paper.
There's no answer paper, sir.
No,
there is no answer paper. That whole concept doesn't apply here. That whole concept, I was giving an example to say it is not like that.
That's why, my lord, they have not stated why when regional level committee.
These are all awards, all subjective.
My regional level committee has already forwarded recommended my entry.
We won't entertain writs like this. We won't entertain writs like this. This is not within our remit.
My lord, may I permit to argue, my lord? Lordship may pass the order. Lord, may I permit to argue because for the satisfaction of my client satisfaction, I have to argue, my lord. So I brought the information under RTI Act. The RTI Act they have supplied when the committee they selected that the central committee as per the in pursuant of the order of this honorable court. When the selection committee, central selection committee intimated to me that since the headquarter level has not made any recommendation, that's why you have not selected him. So that's why I want to call for the records from the regional level and also the headquarter level. The annexure 2 is the RTI application. They have given the entries made under the Design Innovation Award. My name reflects serial number 2. It proves they have received my entry. They have received my entry, and along with the under the heading of Design Innovation Cap, there are 5 entries they have received from the eastern region, and they have sent to the headquarter level. The headquarter level also they given the proceeding under Annexure 4. In Annexure 4, they have already stated that it is the meeting of central level committee. When it is a meeting of central level committee, the headquarter level has not given any report. Why he did not recommend to my entry to the central level? The central level committee has given a report under Annexure 4, page 28, stating that it is a since headquarter level not sent any entry of Design Innovation Award, we have not selected. So that's why it shows without assigning any region, they have not selected mine. And I have paid in 3 prayer, my lord, writ petition. One is, my lord, select the entry of the petitioners for design award, making formalities within the stipulated period. Since I have asked for the award, they have published the award. I have participated, I have submitted my entry. They are either select or reject, but they have to take consideration of my entry. Second thing, if they have not selected, direction may be given to produce my entries, which I was already submitted to them. They have till yet they have not returned my entry. And third, my lord, if the headquarters they have in pursuant of the order of this honorable court, if they have given the communication to me that they have the headquarter level has not recommended, that's why they have not considered. So the members consisting of the headquarter level body, they should file a affidavit showing the reasons why they have not issued. So I have prayed for 3 prayers in my writ petition, and after receiving my notice issued by this honorable court, they have issued a letter to me. I have filed my rejoinder. They have issued my letter that you take back your entry. In my rejoinder, I have annexure 6. After receiving writ petition copy, they have stated that you take back your entry after 2 years, when they have not assigned any reason. So when I went, I saw that they have already broken my entry. I have took the photograph. Lordship, I want to come to Lordship's attention to what is the entry and what was the broken. I want to place, my lord, the photographs. They have already broken my entries, and when they cannot select my by whom and copies, they have to gone by the procedure followed. They are under annexure 1. So they cannot monopoly. They will select to somebody and they will not select to somebody, and they will not assign any region to me. And it is the design, my lord. So my respectful submission, when they have not assigned to any region, then why they have not recommend my name to the central level? That is my reason. So that's why they in arbitrarily since, and also they have not stated in as per the award of 2016, no award has been given in respect of the award, that is Design Innovation Award 2016. Since they have not given any award, the design in respect of Design Innovation Award 2016, and I have submitted my place and they have not assigned any region. So I will be selected for that award.
The challenge in the present, the prayer in the present petition is for a notice, is for a direction to the opposite party, which includes the single court's headquarters level selection committee, represented through its chairman, Development Commissioner bracket Handicraft, as well as the Union of India and the Ministry of Textiles, bracket opposite party number 1, open to select the entry of the petitioners for Design Innovation Award 2016, and quote, and also to produce the entry of the petitioners in this court to ascertain why such product, open quotation, will not be selected for Design Innovation Award, full stop, unquote. This is the second round of litigation involving this issue. Earlier, the petitioner had filed petition civil 7781 of 2018, which was disposed of with this court on 11 January 2019, directing the opposite parties to declare the result of the Design Innovation Award 2016 within 1 week. Full stop. Following the said order, the following letter was written by opposite party number 4 to the petitioner on 5th February 2019, inter alia stating as under. Let's take from para 2 in this connection. Up to the end. Paragraph, the court, the counsel to petitioner takes exception to the fact that none of the entries were found worthy of award of the Design Innovation Award for 2016. Full stop. He's insistent that This court should direct the opposite parties to disclose the reasons why no entry was chosen, and in particular, why his entries were rejected. Paragraph. He has also placed before the court photographs of his entries and insisted that his entries should be returned to him by the opposite parties. Paragraph. As far as the first prayer is concerned, the court is of the view that the reply dated 5th February 2019 received by the petitioner sufficiently discloses the details of the process of selection, which is a two-tier process. Full stop. There is a regional selection committee and then followed by a headquarter level selection committee. Full stop. It comprises, full stop. Then there is a third final level selection committee. Full stop. The composition of each of the committees has also been sufficiently disclosed. Paragraph. The selection of entries for the purposes of conferring an award is obviously a subjective assessment based on objective criteria. Full stop. Since this is not a test or an exam, and it's only an exercise for conferment of an award, the court does not consider it appropriate to insist that the reasons for not selecting a particular entry for conferment of an award should be disclosed. Full stop. These are not matters capable of being assessed by courts. In other words, there are no open quotation judicially manageable standards on court for assessing entries and determining whether the decision of an expert committee on not finding an entry suitable for an award should be interfered with by a court. Full stop. Consequently, the court declines to enter into such an exercise at the instance of the petitioner. Paragraph. As far as return of the petitioner's entries are concerned, if these entries are still available with the opposite parties, then they should return it to the petitioner within a period of 4 weeks from today. Full stop. No further directions are called for. The petition is disposed of.
In para 4.1 of the counter, we have stated that the items have already been returned to the state government. That we have written.
You see, as far as return of the entries are concerned, the counter affidavit filed by the Union of India states that these have already been returned to the state government. So stop, in that view of the matter, a direction is issued to the state government to in turn return the entries to the petitioner within a period of 4 weeks from today.
And the state government, they should have disclosed which department of state government. Means state government means this is a back department. To whom you have returned? You have not stated so.
You have received it in 2000.
You have to say, you have submitted that, you have to say which state government you have given. So you have to approach the.
We have stated, my lord. Thereafter, the headquarter level selection, we again go through the shortlist. And the aforesaid development having been brought to the notice of the Central Level Selection Committee, the same was recorded in the minutes of the Central Level Selection Committee. Since the entries were not selected, those were sent back to the state government for the purpose of handing over to the petitioners.
Must be the handicrafts department, sir.
They have not written matter, only state government. That's why matter by submission.
Must be the
They
handicrafts.
have not given to whom they have handed over.
All right.
Naturally.
The regional level committee composition is known, from that you can find out. All right.
Item number 61.
Yeah, please.
Yes.
Yes, sir.
Item 61, my lord, I have instructions that the petitioner has availed the benefit under the Vivad Se Vishwas scheme. So this matter has become infructuous, my lord, filing a memo in that respect.
All right. The memo is taken on record. The appeal is disposed of as infructuous. What about the connected writ petition?
Connected writ petition, my
That has
lord.
been disposed of.
I see.
My lord, that has been
Already disposed of. All right. Connected writ petition is already disposed of.
3100.
My presence being I'll noted, yes.
Yeah, in view of the above order, this writ petition is also disposed of. All right.
Item 62.
My lord, so this
Sorry,
matter.
well, I'm in BC, my lord. Already counter has been filed. And we were filing, e-filing it because of the 700 pages of bulky paper I have to send one copy, another copy will file it. Sir. Already counter has been filed. 6/12/2000.
You got a copy of the counter?
By email, they have sent it to me. I want a hard copy, Your Lordship. Because
All right.
600 pages.
Hard copy of the counter affidavit be served on the petitioner within 2 weeks. Rejoined thereto if any.
Rejoined, Your Lordship, I have already filed. I have already filed and sent them a copy by email.
He has also sent a copy by email.
I have not.
Mine is very small, 25 pages. And you have 700 pages.
No issue.
Your rejoinder does not come on record.
Your Lordship, it does not come. Just yesterday I have filed, Your Lordship. That is
The
a booking
rejoinder
there.
of the petitioner be
I have
placed on record. Hard copy of the counter affidavit be served on the petitioner within 2 weeks. This for final hearing on.
Your Lordship, kindly call it an early date. Your Lordship, these are 4-year tenure, 3-year tenure, I think. So in the meantime, a matter will be infructuous.
No.
Kindly call it in the month of February.
No time. There's no time. Yes.
Please, sir.
Item 63.
Yes.
Well, in this matter, along with me, Mr. Bhukta name will be reflected.
All right.
Item number 63. I'm for the opposite party, BMC.
Item 63 connected matter, I am for the petitioner, that is 19107/2012. In that case, BMC has already filed a counter stating that they have taken a decision in the higher level committee in view of my earlier writ petition. In that case, order was passed to consider my representation. They have considered and passed the order. Now, state government has to act upon that order. Now, that is in the counter affidavit, they have annexed that they have considered and they have suggested the state government like this one, that taking into consideration all aspects and suggestions given by BMC, it has been unanimously decided to move the government for cancellation of the order dated 13/9/2012, alienating the land for crematorium purpose in Moja Lakshmi Sagar, Merpali. On this, state government has to act.
So we'll dispose it of,
Yes,
let
sir.
them act on this.
The state government.
The counter affidavit filed by the BMC.
By the BMC.
OP4.
WPC 25589.
Which paragraph, sir?
That is annexure A/4, page 7. To the counter filed by the BMC, OP number 4.
Encloses a copy of a decision dated 19/10/2015, addressed to the HNUD department. Conveying the decision to
Page 8 is the proceeding of the meeting. That has been communicated.
Let me see page 10.
Yeah.
And it's
to
the
move the
last-
government for cancellation of the order.
Yes,
Yes.
So the department will move
Yeah,
the
we
government.
move the government for cancellation of the order dated 13th September 2012, alienating the land for crematorium purposes in Moza Lakshmi Sagar, bracket Meherpalli. Paragraph. The directions accordingly issued to the GA department, is it?
Please, ma'am.
Of the state government to act on the above recommendation of the BMC and pass appropriate orders in accordance with law within a period of 12 weeks from today and communicate the decision to the petitioner within a week of its being taken. Full stop. The petition is disposed of in the above terms. What about the first matter? Who's in that?
First matter is that on the basis of the decision taken on 39, which has been cancelled, on the basis of that municipality, they are requesting the municipality to make construction of a smashan on the land.
None appears to the petitioner.
That nobody is appearing, that is infructuous.
Dismissed for non-prosecution.
And for BMC in both the matters, my lord.
Item number 65.
On behalf of Mr. Bahal, my lord, your lordship on order dated 22nd 9/2022, your lordship directed opposite party number 12 to 13 to file a reply, my lord.
Lordship, today I am filing the replies.
All right. Counsel appearing for opposite parties 12 to 14.
Yes, Lordship.
States that he's filing a reply, has filed a reply in court today. Copies been handed over to counsel for the petitioner. It's permitted to file a response there for the next stage. All right. It's on 22nd August.
Item 66, column 22nd August. Item 66.
I am appealing for OP number 9 and 10. I have filed counter. OP numbers 4, 5, and 8. They have filed a counter. They have not served a copy on me. And moreover, Millards, we have acted as per the guideline of the Union of India. They have not yet filed counter. Four, 5, 8 counter may be acted, direction may be issued to serve on me, Millards.
We have solved, we'll solve again. It has been solved.
Not served.
No. 5 and 8, is it on record?
I am for OP number 9 and 10.
Who's for the petitioner?
I am there.
Ah.
I am there for the petitioner. My grievance is, my lord, the petitioners are all belonging to Gram Panchayat of Kantabana, and there is a scheme, my lord. Under the scheme, this
crop loss.
Pradhan Mantri Bima Yojana. And under the scheme, a particular modalities are fixed, and as per the modalities, every year the average yield will be taken and the actual yield will be taken, and comparatively, if there is any loss in the area, they will pay it.
And you offer 9 and 10?
Yes, I am for 9 and 10.
He wants copy of the counter of the other party.
Yes.
Counsel appearing for, you say copy of the counter affidavit of opposite parties 4, 5, and 8 be served on counsel appearing for opposite parties 9 and 10 within a week. He is permitted to file a reply to the said counter affidavit before the next date. The petitioner is also permitted to file joinders before the next date.
Union of India has not filed the counter so far.
Meanwhile, the Union of India will file its reply within 8 weeks. List on 23rd August.
Item 67.
May I please, Your Lordship? This is with regard to challenge to a new source, Balighat, that has been created, which will affect the inhabitants of the locality and also contrary to the stipulations made in the rule. Here initially, these notifications in respect of the new source under Annexure 1 was published. After the notification was published, Your Lordship,
this is for sand mining. New source for what?
Sand sirat.
Sand sirat.
Sand sirat. Now we filed also objection to that under Annexure 2 series at page 22, which was duly received by them in the month of June 2020. Therein we pointed out that the embankment is very weak and it will be damaged if this new source is created. And the 500 acres of land, agricultural land, which is there in the other side of the river, the access will be closed. And there are school and other temples and other things. And these vehicles will pass right through the village, which will definitely cause health hazards. That was not considered. A writ petition was filed since the rule was not complied with regard to reprehension, reasonable court was pleased to permit us to make a reprehension, and specific direction was issued that will be considered. After that is filed. Now, my lord, on the basis of the direction of reasonable court, the sub-collector at page 27, your lordship, notes our presence. And then, considering that there will be, my lord, danger to the embankment and all those allegations that have been made by the petitioner, he calls for a report from the Tahsildar and also from the Assistant Executive Engineer, Irrigation Division, Balipatna. Your lordship will see that is on 24/12/2020. Because why I am pointing out this to your lordship, the last portion your lordship will see put up the case after the receipt of report. Now, no further date was communicated to us, nor this inquiry regarding the report or anything was done in presence of the villagers. Now, suddenly on 31/2021, the court notes that the reports has been filed and the case is reserved for order. Now, after reserving for order, as it appears from the order dated 15/1/2021, your lordship, more particularly the last portion at page 29, the sub-collector takes note of the report and says there are some concern with regard to embankment and everything. And he says this should be taken care of. Now, my lord, I filed the writ petition, notice was issued, so cause has been filed, but they have entered into an agreement with the person in whose favor they have settled pursuant to the action. Now, the lease deed also doesn't contain any such measures which has been suggested by the sub-collector in the order itself. And sub-collector says, we have not filed any objection. That is the premises on which they have proceeded. Though pursuant to the direction of the reasonable court, we filed objection. That has been taken note of in the order sheet. And my lord, he calls for report without supplying a copy of the report to us or during inquiry without allowing our participation. This decision was taken. Even the counter affidavit that has been filed, your lordship will kindly peruse. The reports have not been produced before your lordship to show the justification that yes, the reports, the concern that was expressed, because the reports have not seen the light of the day till date. Either the report of the Tahsildar or the report of the engineer, because it was the embankment concern that was there and other things, my lord, because the school, temple and other things are there, that is there. Only thing he takes note of is saying that there is an alternative route. And about the agricultural land, everything and non-access, those things has not been taken care of. And your lordship will see the impugned order, he repeatedly says that no objection has been filed. The reasonable court was pleased to relegate us. We filed objection that was taken note of. No further date was communicated. I have stated in the writ petition. And in answer to that, nothing has been said in the counter affidavit. Your lordship will see in the counter affidavit, they have not denied my statement that I was not communicated about further date. It is only when he tried to start work, we inquired, we applied under the RTA Act and got the copies, and therefore the writ petition was filed. And here, my lord, also in the lease deed which has been executed, your lordship will see those concerns has not been taken care of. And as to what is there in the report itself, that is not also revealed before your lordship.
No, but what they're saying is that sand source, a huge amount of illegal mining is happening.
But the only thing is that your lordship will see,
unscrupulous mineral mafias are making huge amounts. No,
but they have to stop, and they have framed a rule where they say where they should not do it. Concern to the embankment and these inhabitants nearby and my agricultural land, nothing has been denied. Your lordship sees in the counter affidavit. And the reports are not also produced before your lordship. Reports also, the sub-collector doesn't explicitly narrates what is there in the report, except saying that some concern has been expressed that may be taken care of. Your lordship will see the order itself at page 29, last paragraph onwards, that one paragraph.
No, just come to paragraph 7. It's a very big paragraph. Internal page 8.
Internal page 8?
No, page 5, sorry. Actually, bottom of internal page 4. This is the counter of 1 to 4.
Counter, my lord.
Of 1 to 4, bottom of page 4. The sub-collector having analyzed the report.
My counter. I'm sorry.
My counter, page 4.
Yes, my lord. I got it. My lord, I got it. But that your lordship will see. Your Lordship may see the sub-collector's order.
Yes.
What he has said. Now, what they are trying to supplement by saying that there are all directions, but what is there in the report and whether that will be justified to open a new source or not, that is not revealed, my lord. These are all remedial measures which they have suggested. But this is the difficulty. My lord, I am not saying that if there is a source and it gives revenue, it should not be done. But it is not at the cost of what they have prohibited in the rule itself.
No, but what more needs to be done then?
And what they have done recently, they were taking to the village and now they picked up some of the persons and they took them to the police station without registering any case, detained them for 2 days, then allowed them to go. This is what they are, this is the kind of harassment they are doing. And that is a post facto incident which I have not been able to brought an affidavit. I should have brought. But this is the situation, my lord, I beg to point out and leave it to your lordship's consideration. But, and the report, my lord, they could have annexed the report to say, no, the report, this is the position and we have taken care of. And my specific stand in the writ petition, your lordship, is that the report has not been supplied to us.
No, but there is no stay. So obviously this, this is going
It has started. I'm not disputing that. And in fact, I beg to point out
violating any of these conditions, you bring it to a notice.
In fact, I beg to point out one more thing. In deference to the fact that the case is pending, they did not commence the operation for long.
Anyway,
now maybe with the advice or whatever it is, and justifiable because there was no interim order of stay. They post facto during the pendency of the writ petition they started, and after a long period of pendency. It is not that from the inception they started it.
This is the second round of litigation concerning the identification of a new sand source in river Kushabhadra and village Marthapur. Police station Balipatna.
With your lordship's permission, may I just point out humbly one thing, if I am pardoned to my lord? They said there has been an alternative route.
Sorry?
With your lordship's kind permission, I may be pardoned, my lord. They have said there is an alternative route. That is what they are taking plea. So all these safety matters, whatever, if they are not ensuring, I may be also granted liberty to bring it to their notice for action. That much. Lordship.
In the first instance, the petitioners had filed writ petition civil 28878 of 2020, which was disposed of by this court by an order dated 23rd September 2020. Sorry, no, by order dated 3rd November 2020, requiring the sub-collector Bhubaneswar. No, requiring the Tahsildar.
No, my lord, sub-collector.
Sub-collector.
May I read out, my lord? Sub-collector.
Sub-collector Bhubaneswar. To give the petitioners a hearing and pass a fresh order. Full stop. It is claimed by the petitioners that they were not informed of the further hearings before the sub-collector and came to know of an order dated 15th January 2021 passed by him only when steps were taken to lease out the sand Sairat source. Full stop. In fact, a lease deed was executed on 17 March 2022, leasing the aforesaid Sairat source in favor of opposite party number 5 for a period of 5 years. Paragraph. Challenging the grant of the said lease, the present writ petition has been filed. in which notice was issued on 2nd June 2022. Pursuant thereto, a reply has been filed on behalf of opposite parties 1 to 4. Where inter alia it is stated that knowing of the availability of the sand deposit at the said source, there had been illegal lifting and theft of sand by unscrupulous mineral mafias, resulting in huge revenue loss to the state exchequer. Full stop. It is further stated that on 24th December 2020, the sub-collector had called for an expert opinion from the AEE Irrigation Division to assess the alleged damage to the embankment and riverbed as apprehended by the petitioners in the event the source was given on auction. Full stop. Thereafter, the reasoned order was passed on 15 January 2021, incorporating the inputs of the SDO Balipatna irrigation and building in certain precautionary measures such as prohibiting carrying on of the excavation of sand on the embankment, not lifting of sand during rainy season, proper demarcation of the boundary of the source, excavation to be a minimum 100 meters away from the river embankment, and maximum excavation of 1.5 meters of depth. Stop. %1 of the bid value has been kept with the executive engineer in the form of a term deposit receipt as security against inadvertent damage to the river embankment. Paragraph. It appears that with there being no interim order by this court, the said lease is today in operation. Paragraph. It's also stated that the apprehension that trucks will be passing through the village roads causing health hazard is unfounded, since open quotation, there is an alternative road available for transport and the proposed lease will not affect school, religious places, etc. Unquote. Having heard and counseled the parties, the court is of the view that the apprehensions of the petitioners appear to have been adequately taken care of by the sub-collector in passing the impugned order. Stop. In the event that the petitioners find that any of the conditions of the lease, as mentioned in the counter affidavit, have been actually violated by opposite party number 5, they should promptly bring it to the notice of the sub-collector. And if so done, the sub-collector will promptly inquire into the matter and take the necessary corrective action. Stop. If there's any failure by the sub-collector to take corrective action, it will be open to the petitioners to seek appropriate remedies in accordance with law. The same holds good as far as the apprehensions expressed as regards transportation of sand by trucks passing through the villages, in view of the assurance given that it is only the alternative route identified for the purpose which will be used. Paragraph. With the above observations, the petition is disposed of.
Grateful, my lord.
Item 68.
May I please your lordship? My lord, my refund application flowing from the return TDS amount has not been allowed by the
allowed by the cell type officer. So as per your lordship's order, commissioner has issued the circular. Let it be considered in accordance with the circular.
All right.
Second paragraph, my lord. In the meantime, some works contractor had approached the Honorable High Court of Orissa for appropriate relief. The Honorable High Court has recently disposed of a number of such writ petitions, a few of them detailed below, stating that there is no limitation prescribed under the Act or rules which put a bar on carrying out tax audit for the purpose of considering such refund applications which flow out of tax returns. Therefore, in view of the order, observation of the Honorable High Court, the 5 years audit limitation provision is not applicable to such claim of refund. Claims of refund by works contractor pertaining to any tax period and flowing from their return shall henceforth be disposed of without any limitation in the following manner. So I pray that my refund applications under Annexure 1, 3, and 5 may be disposed of in accordance with this circular.
Mr. Mohanty, learned counsel, the petitioner has placed before the court copy of a circular dated 28th September 2017 issued by the Commissioner of Commercial Taxes, Cuttack, on the issue of refund of excess tax paid by works contractors without insisting on a limitation period. Full stop. Paragraph. He states that as long as the petitioner's pending refund applications are considered by the commissioner in a time-bound manner in terms of the said circular, the petitioner would not press for the reliefs prayed for in the present petition. Paragraph. Accordingly, the following directions are issued. The petitioner will submit an affidavit in terms of the said circular dated 28th September 2017, enclosing the relevant TDS certificates.
My lord, yes, ma'am. As per TDS certificate.
As per that circular,
As per the circular to the commissioner not later than 1st March 2023. To the commissioner, on receiving such application, will proceed in accordance with law and after hearing the petitioner, pass an appropriate reasoned order thereon within a period of 4 months thereafter. Full stop. The court clarifies it has not expressed any view on the matter. The petition is disposed of.
Your Lordship, as per that.
Who, the commissioner only considers the refund application or who does?
No.
Cell tax officer. Cell tax officer, Ponjam 1 circle. Yes, ma'am.
The assessing of authority will after hearing. All right.
Your Lordship, as per that circular.
Yes.
Annexure 1, 3, and 5 is my refund applications. That are to be considered by the.
But you have to make it again in that affidavit in terms of the circular.
Affidavit, and it is to be referred to a special audit, and special audit
Yes,
is
my
to
lord,
be
my
conducted.
lord.
Your Lordship,
My
as per
lord,
that
that's
circular.
fine.
Your Lordship. My lord.
Item 69.
My lord, 69 is an audit assessment. So it has been challenged before your lordships and interim order is continuing.
So appeal.
My lord.
Petitioner seeks leave to withdraw the present petition with liberty to challenge the impugned assessment order in accordance with law and an appeal. Such appeal is filed not later than 3rd April, accompanied with an application for delay, citing the pendency of the present petition as the reason for the delay. It will be considered with the appellate authority in accordance
My lord,
with law.
interim order is contrary. You are
Yes, yes.
possibly protected.
If the appeal is filed within the time stipulated along with an application for interim relief, then till such time the appellate authority passes an order thereon. The interim order passed with this court on 10th April 2017 will continue. The court clarifies it has not expressed any view in the matter.
Return of assessment order, my lord.
The originals of the annexures be returned, subject to being substituted with attested photocopies.
Obligement.
Item number 70.
Item 70, my lord, I am appearing for the opposite partner 1. I received instruction. I'll counter in this case with time be allowed.
All right. Mr. Mahapatra seeks and is granted a last opportunity of filing a reply within 8 weeks, rejoinder for the next date.
My lords, my appearance may be.
Or interim order.
Yes.
Interim order to continue. List on 23rd August.
Great. On behalf of Mr. Mahapatra, he's not. Mr. Roy.
Yes.
Item 71.
Well, I'm virtually appearing, my lord.
Yes, sir.
Well, this is challenge the notice, initiation of notice, initiation of reassessment. In pursuance to change, in my lord, in change of opinion, they have issued this notice. Kindly have a glance to Annexure 1. That is page 12. First, they issue the notice. This is under the CST Act. They have not assigned any reason. And subsequently, is it my cover, my lord?
No.
My lord, judgment, that is Jagannath promoters and builders. I have supplied that copy of that.
Yeah.
No, here your lordship may Annexure 2, may kindly turn to Annexure 2. In Annexure 2, your lordship, the reasons have been given, your lordship.
That reason is already
Annexure 2, page 14 and page 15, your lordship. This is the 12th for assessment, your lordship. At page 15, the reasons, enter reasons have been recorded and issued to the petitioner, your lordship.
No, but this reason already was there in the original assessment.
Yes, it is only change of opinion, man.
Your lordship, it is under assessed, your lordship, so far as this case is concerned, your lordship, here the provision is that escaped assessment, under assessment, and your lordship has been assessed at lower than, your lordship, it is not only escaped assessment, your lordship.
No, but here, you have in the tick marked escaped assessment.
Your lordship, that is under assessed, your lordship, but Annexure 2.
No. Just come to page 12. Escaped assessment.
Your lordship, but Annexure 2, it is been written as under assessment, your lordship. You are hereby informed that you have been under assessed.
You can't shift Anyway, this reason he says is forming part of the original assessment.
Yes, kindly have a glance to page 19. That is audit report.
Yes.
That is in the column, the Liberty Marine Syndicate and Signer, that Form H has been filed. And now they are telling you have not given all details. So this has been in the audit report and subsequently in the assessment order also, my lord, that is at page 23. Para 1, para 1 that mentioned that export sale to tune of ₹5 crore is allowed in total after verification of declaration Form H and connected documents. So they verified the Form H and connected documents and allowed that. Now they are telling in the reason that there is no documents has been given. So these have already been considered. And this I have given the judgment of my lord judgment. That is Jagannath promoter builder, that is WPC number 14603, that is in change of opinion. In the garb of review, change of opinion there.
Your lordship, in my annexure, in my counter, page 28 and 29, pursuant to this notice, the petitioners appeared before the assessing officer and submitted the document, your lordship. So let the assessing officer may consider, your lordship. Your lordship, this is all the proceeding. This is the notice has been issued. Pursuant to the notice, the petitioner by date on date
2017, it's been pending here.
Your lordship, on dated, subsequently in my annexure 20, page 29, annexure B/1, page 60. Page 60 and 61, 62, your lordship, the petitioner himself appeared before the assessing officer and produced all the documents. So due to the interim order here, your lordship, the officer has not considered, your lordship. So let the officer consider, your lordship. These are the factual position, your lordship. Factual aspects, your lordship.
Apart from that section 5, and subsection 3, my lord has also given now recently a judgment that when Form H
and the irregularities are so far.
No, Mr. Harichandan, I think the only point is no order has been passed yet because of the stay order granted by this court.
My lord, that is the case of the Jagannath also, that which I have given.
No, Jagannath promoters is Income Tax Act.
Income Tax Act, my lord, in that case also in the notice stage I have challenged that.
147, so 147 as well as these provisions, 12.4 as well as 43.
From the documents, it's clear that all these formats have been accepted by
Let him pass an order, sir. Now that you've placed all the materials on record, let him pass the order.
Then I may be permitted to file my preliminary objection and other things.
Yes. All right. You say the petitioner approached this court challenging a notice dated 22nd December 2014 under Rule 12 bracket 4 of the CST bracket Orissa bracket rules 1957 for the period 1/4/2009 to 31/3/2010 on the ground of single quotes escaped assessment, unquote. Paragraph. Although when the reasons were furnished by the letter dated 13th February 2015, it was stated by the Joint Commissioner of Sales Tax that the petitioner had been single quotes under assessed, unquote, for the year 2009-10 by single quotes irregular allowance of exempted export sales to Messrs. Sainath Industry bracket Private Limited and Messrs. The Liberty Marine Syndicate Private Limited under Section 5 bracket 3 of the CST Act, full stop, unquote. The contention of the petitioner was that the above transactions already form part of the original assessment order issued by the assessing authority.
In annexure 4.
Therefore, the reopening of the assessment by issuing the imbue notice was only on the basis of single quotes change of opinion, unquote. He accordingly seeks to rely on the judgment of this court dated 8/12/2022 in STREV 64 of 2017 bracket Messrs. General Traders Berhampur versus State of Orissa bracket. The fact remains that the petitioner is yet to reply to the notice issued to him, and no order therefore has yet been passed by the assessing authority. In
General Traders with regard to the 5-3. That is another Jagannath promoter I have given.
So General Traders you've given us.
General Traders with regard to the
Jagannath Promoters is 147 Income Tax Act, sir. Please.
My lord.
We're not going to cite that. Yes.
Okay, my lord.
In view of the interim order passed by this court on 17/10/2017, paragraph. Accordingly, while vacating the interim order, the court directs that the petitioner will file his reply to the imbue notice on or before 3rd April 2023 and urge all the points that the petitioner wishes to urge in accordance with law, including citing the decisions referred to hereinbefore. The assessing authority will, after hearing the petitioner, pass an appropriate order thereafter, not later than 3rd July 2023 and communicated to the petitioner within a week thereafter. The court clarifies it has not expressed any view in the matter. The petition is disposed of.
My lord, may I raise the plenary objection with regard to jurisdiction initiation?
All points you can raise, sir. Every point, and hereafter, what new points also you think you can raise?
Obliged, my lord.
Item number 72.
Your Lordship, item number 72, in course of day today, I have filed one reply to rejoinder. Your Lordship, some specific allegations are there in the rejoinder that no communication has been done, Your Lordship, so far as the discrepancies are concerned. I have served the copy.
Yes, sir, rejoinder, my lord, I have received a copy.
Oh.
I was only praying.
So it
and I'd consider whether I'll file a reply to this sir rejoinder or not.
So you have to stop it somewhere.
Lord, your lordship, so would only pray, my lord, your lordship may call it next week. The urgency in this case, my lord, considering the urgency, your lordship have fixed it to today, because this is a refund application which is now being denied to an industry who is manufacturing e-vehicles, my lord. And because of the inverted tax duty structure, my lords, I am liable for refunds, my lords. And each year, my lord, this is continuing, my lords. I go to an appeal, they give it to me. This year, my lord, even though the CBIC circular has been followed, they still reject. So, your lordship may call this next week.
The only dispute is that whether there is the requirement of the books of accounts will be there or not. Whether that only that is the issue.
Your lordship may call it next
where
week.
Department says that you produce the books of accounts, there the petitioner says that no production is not required as per that. Only that portion, only that issue is to be considered. Nothing more. Your lordship, but without books of accounts.
Your lordship may call it next week, my lord. I'd humbly pray your lordship may decide this case.
All right. At the request of Mr. Sunil Mishra, list on, not next week. 2nd May.
2nd May. May I just-
73.
Great respect, my lords.
This all
At least
talk-
in the last week of February, my lords.
It's all very full. Let's say.
Because if it
Completely.
goes beyond March, my lord, I am in a difficulty, my lords. Because I am not unable to also service my bank loans, my lords. I'm sorry for the inconvenience, my lord, but
No, but it's only that, okay, 13th April. All right,
13th
April.
73.
And no more surrey jaundice.
No, my intention is not
All
to
right.
avoid.
All right.
Bless you.
73 is the same thing, right?
73 is the same.
73,
I've not-
I have not filed in a day or two, your lordship, same, your lordship,
All right.
same. Your
Let's talk.
Item 74.
lordship, my record copy has been solved, your lordship. Obliged.
All right. Memos taken on record. Dismisses withdrawn.
Item number 75.
Item 75, my lords, with due humility, the petitioner, my lords, the scientist passed away. My lords.
All right. Counsel to petition. Appellant appears to have passed away. The petition appeal is dismissed as having abated. All right.
Item number 80. Item number 80.
My lord, I'm on VC, my lord. Item number 80, we are not pressing the writ appeal, but the corresponding writ petition may be directed to be expeditiously disposed of.
It's already disposed of. The writ appeal is.
Your lordship, I am appearing on behalf of Mr. S.B. Jana for OP number 3.
All right. Disposed of is not pressed. All right. Is item 1, when is it going to be called up? Not this week, is it? Item 1, you call out again.
Yes, I will call out. Weekly list, item number 1.
And here, I had prayed for an argument yesterday, which was objected to, my lord, rightly, because this is old case. This is a work-up matter, where like a suit, it was trial was done before a tribunal. Now, this is in nature of a writ petition because there is no other remedy available. I have to assist your lordship with reference to the record and vis-a-vis the legal position. But will your lordship be kind enough? Can be 2-3 days time? I'm trying to master it to assist your lordship properly. I know, my lord, my friend has objected. If your lordship fixes it to also 2 p.m. on Monday, I'll do it, my lord. It's not that I have any intention of.
I think we'll stay. We'll call it on Thursday. Today's Tuesday. We'll call it on Thursday.
Can it be on Monday? I get a weekend time to
right.
investigate.
Not till
that
Monday.
much.
All right.
Deeply grateful, my lord. Deeply grateful.
Item number 4.
Your lordship, on behalf of senior advocate N.K. Mishra, this matter may be taken up tomorrow, your lordship.
Anyway, stay on board. All right.
Much obliged, your lordship.
Item number 7.
May I please, your lordship?
Sir, my lord, the award of the Learned Labor Code has been challenged on the ground, my lord. The page 18 is the relevant portion of the award. Only on the ground of the petitioners are the apprentice under the opposite party management. They have not considered as the workman. On that score, that has been awarded. Even though the specific of Industrial Disputes Act says apprentice includes the definition of workman, which is available under 2(s) of the Act, my lord.
Who's for the management? Okay.
2(s) is the definition.
All right. You see, none appears for the opposite party number 1. This has gone into liquidation, no? This is opposite party number 1.
This is Balarpur Industries.
I think it's in liquidation, sir. It went before the NCLT and all that. Ballarpur went into liquidation, sir.
The award of 2014, my lord. Since liquidation.
Get confirmed from Mr. Aditya Das. He must be knowing that day he was mentioning that it was.
That is, I think, that NCLT proceeding is pending against Ballarpur.
Built.
Before NCLT.
NCLT. Ballarpur Industry.
Your Lordship.
What do you wish to do? You want to find out, you'll stay on board, you find out.
Let it be in the board, rather I will contact.
Even Mr. Shibashish Mishra will know.
Aditya Das is the counsel of.
Aditya Das.
He was doing the tax matters. Other counsels may be there.
Right.
I will find out, my lord.
Yes, it will stay on board.
Deep blue line.
Item 28.
Well, as item 28, this is the BSNL land acquisition matter. My lords, I have sought for instructions from the collector Koraput regarding the RDC's letter. My lords, may be given 2 days time. I'll file a affidavit by the collector Koraput on this particular, on the RDC's letter dated 20th of.
Call on Thursday. Let's see.
Weekly list old matter item 34.
My lord, item 24, my lord. Item 24. Old matter.
24.
24. 24, I have sought the copy to Mr. Manti, Pranay Manti, as per my lord's direction.
Just a copy, my lords, just now I have received the copy. We call it on Thursday. All right.
Thursday.
My lord.
Item 34.
My lord, the matter can be taken up tomorrow, my lord.
All right.
Obliged. Item 35.
None appears dismissed.
Item number 36.
None appears dismissed.
Item number 37.
Item number 37, I am for the opposite party.
Okay. None appears to the petitioner dismissed for not persuasion.
Obliged.
Item 38.
None appears for the petitioner dismissed.
Item number 39.
None appears for the petitioner dismissed.
Item number 40.
Item number 40, my lords. First of all, I beg apology before my lords because of I've gone through the file, my lords, because of my latches. I think latches of my office. As things have gone, my lords, beyond my control. And I pray, my lords, fact remains, my lord, 2011, my record shows that we have deposited the requisite on 30th January 2012, my lords. But file shows that no requisite has been filed. I am not in a position. In the meanwhile, my lord, the matter has been referred to, my lords, permanent Lok Adalat. So with due humility, my lords, this is a case, my lords, where the petitioner has a house over a particular portion of the land, what the vendor mortgaged 15 years before in a bank, my lords. That is what he suffered. Now he's staying there. This is only about. I pray, my lords, to be kind enough, my lords, fountain of justice, my lords. I can't say anything more. If it can be remanded again for reconciliation by the balance of
No, it went before the Lok Adalat several times.
Went before the Lok Adalat, my lords, with my client. I inquired from my client. He has not
appearing at all there, sir.
Then
nobody's appearing.
Not appearing, my lords. I have also not got instruction, my lords.
All right. See, it appears that no
May I pray, my lords? May I pray, my lords? Kindly look at the plight of that person, my lords.
No, sir. We'll permit him to approach the banks.
May I small prayer, my lords? Yes. I will approach. I have deposited 3 lakhs of rupees here, my lords.
That will ask them to give it to the bank, and then he can go for the remaining to the banks.
I will file a petition before the bank.
Yes,
Let the bank consider it within a stipulated time. Right. Till then, interim order to continue.
You see, counsel to the petitioner states he has no instructions from the petitioner. It is seen that despite the matter being referred to the permanent and continuous Lok Adalat,
he has not received, my lords, any notice.
On several dates, none appeared before that forum.
No, I've taken only add one thing, but I've taken instruction. He has not received any notice.
Anyway, sir, we're not getting into all that. You see, it is seen that the petitioner, pursuant to the interim order passed by this court, petitioner deposited rupees 3 lakhs with the registrar judicial of this court. In the circumstances, the court directs that the said sum will be made over by the registry forthwith, together with any interest accrued thereon, to the opposite party number 1, State Bank of India, Forest Park Branch, Bhubaneswar, Full stop. The petitioner permits, the court permits the petitioner to make a representation to opposite party number 1 not later than 3rd April 2023 regarding proposing the discharge of the remaining liability. The said representation will be considered by the opposite party number 1 bank, and an appropriate order be passed thereon after hearing the petitioner within a period of 2 months thereafter. Full stop. There is no interim order passed by this
Yes,
court.
my lord, interim orders.
Till such time, the interim order passed by this court on 16 January 2012 will continue.
It's a small.
The petition is disposed of.
My lord, small pair. The petition is disposed of, my lords. My lords, a small pair, leave, my lord, if I bank will not consider, I'll.
Obviously, sir, that's not. Yes.
Item 41.
None appears dismissed.
Item number 42.
My lord, may I please your lordship? My lord, a petitioner died and a miscase for substitution is filed, my lord. My lord, may kindly allow the legal heirs applicant to pursue the writ petition, my lord.
What's the matter about?
My lord, in the writ petition challenge the order passed by the learned Commissioner Land Records, my lord, dismissing, my lord, the application under section 36 of Consolidation of Holdings Act, my lord. The petitioner has purchased land by a registered sale deed, and in the consolidation operation, the land reduced, my lord. He was challenged before the authority.
I am appearing for the opinion number 3 to 6. Your lordships kindly have glanced to paragraph 8, concluding paragraph of the impugned order, annexure 10, my lord. At page 113, your lordships kindly have glanced to paragraph 8. Basing on the compromise, and that compromise was acted upon, and accordingly, the petitioner sold out some property out of the allotment made in the compromise. Now he is saying that that was a fake.
No, my lord, that compromise, in that compromise, the petitioner has not signed, my lord. The petitioner has all along challenged that compromise, my lord.
Who's going to get into all that, sir? You can't inquire into all that in the writ petition.
My lord, all along he has challenged that compromise. He has not a party to that compromise.
Nobody's believed you, sir. Concurrent findings against you on that.
So liberty may be given to approach the civil court.
Thank you. For you.
Counsel the petitioner. You see, the challenge in this petition is to an order dated 31st October 2011 passed by the Consolidation Commissioner, Orissa, allowing the revision petitions filed by the opposite parties 3 to 11.
Yes, sir. 3 to 6, my lord.
3 to 6.
3 to 6. 3, 4, 5, 6.
Setting aside an order dated 6/9/2002 passed by the consolidation officer in remanded appeal cases 71/98, 73/98, and 81/98. Full stop. Consequently, the orders dated 17th April 2004 of the Deputy Director in appeals number 419 and 129 of 2003 under section 12 of the Consolidation of Holdings Act was also quashed. Paragraph. The main grant of challenge in the present revision, writ petition to the impugned order is that in para 8 of the impugned order, the contention of the petitioners that the compromise petition that ended the dispute between the parties was not signed by the petitioner was disbelieved. Full stop. The above contention of the petitioners that they were not parties to the compromise petition was disbelieved not only by the commissioner but concurrently by the deputy director and by the consolidation officer. Full stop. This is a pure question of fact, which obviously cannot be gone into in a writ petition, considering that it is disputed. Full stop. Faced with the above prospect, counsel the petitioner states that liberty may be granted to the petitioners to question the compromise and other appropriate proceedings in accordance with law. Paragraph. Granting the above liberty to the petitioners without expressing any view on the tenability of the plea and affirming the order dated 31/10/2011 of the Commissioner. The presented petition is dismissed.
Okay. Eleanor 43.
43 minutes?
43.
43
not pressed.
Dismissed is not pressed. All right. My appearance may be muted.
Item 44.
Well, I am also appearing in this case. I am appearing in this case on behalf of the bank.
None appears to the petitioner dismissed.
Item 45.
No, permitted to withdraw.
Dismiss is withdrawn.
Item number 46.
I am for opposite party.
All right. None appears to the petitioner dismissed.
Item 47.
No, appearance may be required. I am for the opposite party.
None appears to the petitioner dismissed.
Item 48.
None appears dismissed.
Item number 49.
None appears to the petitioner dismissed.
Item 50.
Item 50, madam, I am for the petitioner, madam. Madam, the petitions are tribal people, madam. They have 5 plots of agricultural land that has been illegally acquired by the government, madam, opposite parties, and without any notice, without any intimation. And now they have widened the village road for which my 5 plots have been affected, madam. Out of 5 plots, 2 plots have already been fully acquired, and the other 3 plots have been partially affected, madam. And there are several trees over that land that has also been cut down by the statutory authority, by the help of a contractor. And annexure 5 to my rejoinder application, that is also pending before the sub-collector, my lord, for demarcation of the scheduled land and for a joint verification, but that has not yet been done by the statutory authority. That is pending since 2016, man.
Let me see my counter affidavit. Unless there is no acquisition that was initiated at any point in time. And in fact, no construction work was also going on. Let me see para 8 of my counter affidavit at page 4. My lords. The 4th line. The petitioners are harvesting their agricultural produce each year, as it is already stated. No
construction, no widening of the road, nothing, sir.
And then 10 millers. The petitioners are still continuing in possession of the plots.
And they're cultivating it.
1424. The petitioners are not deprived of the right of possession since no construction or widening of road is taking place. And no acquisition has started as contended by the petitioner.
All disputed questions, sir. How do we get into all this?
There is a bridge over a canal, my lord, that has also been extended to the plot of the petitioner. And my annexure 5 to the rejoinder application that is pending before the sub-collector, my lord, they have also not taken any action over that, my lord.
Rejoinder.
Annexure 5 to my rejoinder application.
When did you file this application?
The rejoinder
that has been filed in the year 2016, my lord. And that has been received by the sub-collector and SDM.
But you didn't do anything about it. In fact, you've added this as a new cause of action. This is a 2013 writ petition. You've just done something in 2016 and slept over it. It's 2023 now. File a fresh application, sir.
Because of the widening of the road, my lord, my 5 plots have been affected, my lord.
They're disputing there is any widening. There's completely disputed questions, sir.
Now, the petitioner has approached this court on the basis that due to road widening processes, there has been forcible acquisition of recorded plots 1424 to 1426 and 1433 in no address, nothing. What is this? The plots are where? What's the address of these plots?
What is the plot of? What is it? In page 3, my lord, last paragraph, plot numbers 1425.
Where? There has to be some Moza, some district, some Tehsil, nothing indicated.
That is in Ukam village in the district of Mayurbhanj.
In Ukam village in Mayurbhanj district?
Yes.
All right. However, in the counter affidavit filed on behalf of opposite parties 1 and 2, there is a categorical denial in para 8 as under, reproduce para 8, page 26. There is therefore highly disputed questions of fact which obviously cannot be examined by the court in these proceedings. Full stop. Counsel to the petitioner then claims that 3 years after filing the writ petition, petitioners had approached the sub-collector
Yes.
for demarcation of their plots. A photocopy of the said application stated to have been received by the sub-collector on 10th March 2016 has been enclosed. Paragraph. A direction is issued to the sub-collector Mayurbhanj. But this says SDM Rairangpur. Sub-collector and SDM Rairangpur.
Yes, ma'am. Sub-collector is of Rairangpur.
No. That stamp of the sub-collector is something else, it says. Bamaguda, is it?
Baman Ghati, Rairangpur. Sub-collector and SDM Baman Ghati, Rairangpur. Baman Ghati, Rairangpur.
Acha, Baman Ghati, Rairangpur. To dispose of the said application, if not already disposed of, within a period of 12 weeks from today. No further directions are called for, the writ petition is disposed of.
Item 51.
51, my lord, infructuous.
Infructuous dismissed.
Item number 52.
52, your lordships, I'm paying for a Passover.
So,
Item number 53.
Your lordships.
53, I am for the opposite party. 53 and 54.
none appears to the petitioner, dismissed. 54 also.
Item 55.
None appears. Dismissed.
Item number 56.
None appears, dismissed.
Item number 57.
None appears, dismissed.
Item number 58.
Maybe tomorrow, my lord.
Item 59.
None appears, dismissed.
Item number 60.
None appears, dismissed.
Item number 61.
None appears, dismissed.
Item number 62.
May it please your lordship. My lord. May it please your lordship.
Yes, please.
My lord. This is an order, your lordship, that is passed by the learned Commissioner of Endowment, which is under challenge before your lordship, under Annexure 3. My lord. This order is not sustainable, your lordship, for the very simple reason that is an order against a dead man. The father of the petitioner, your lordship, Gandharva Mahanti, and his brother, Kartika Chandra Mahanti, they both have purchased a land way back in 1959 from the Marfather of the deity, with all when that was not taken over by endowment. Your lordship may kindly see Annexure 1.
Who's for the other side?
I have served a copy on Learned Council. Mr. Das, I have served a copy, your lordship.
Who?
Mr. Das.
SP Das, your lordship, he's ill actually. I got, he's not well. He's so,
Then we take it up tomorrow.
my lord.